Excellent.
Morning, Attorney.
Morning.
You ready to go?
I am, thank you.
Always ready, I'm sure. Okay. Got a technical issue, have you?
Have we got any swearing in today?
Yeah, we have. Two to swear.
Let's get started.
We might push on and see how we go. All right. Welcome to the additional public hearing for the inquiry into budget estimates 2021-2022. Before I commence, I would like to acknowledge the Gadigal people who are the traditional custodians of this land. I would also like to pay respect to the elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginals present. I welcome Attorney General Mark Speakman and accompanying officials to this hearing. Today the committee will examine the proposed expenditure for the portfolio of Attorney General. Before we commence, I would like to make some brief comments about the procedures for today's hearing. Today's proceedings are being broadcast live from Parliament's website, and a transcript will be placed on the committee's website once it becomes available. In accordance with broadcasting guidelines, media representatives are reminded that they take responsibility for what they publish about the committee's proceedings. All witnesses in budget estimates have a right to procedural fairness according to the procedural fairness resolution adopted by the House in 2018. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide the answers within 21 days. Excuse me. If witnesses wish to hand up documents, they should do so through the committee staff. Attorney General, I remind you and the officers accompanying you that you are free to pass notes and refer directly to your advisors seated at the table behind you. And finally, could everyone please turn their mobile phones to silent for the duration of the hearing? All witnesses will be sworn prior to giving evidence. Attorney General Speakman, I remind you that you do not need to be sworn, as you have already sworn an oath to your office as a Member of Parliament. I would also like to remind the following witnesses that you do not need to be sworn, as you have been sworn at an earlier budget estimates hearing before this committee. Mr Michael Tidball, Secretary, Mr Paul McKnight, Ms Anne Campbell, Ms Karen Smith, Mr Paul O'Reilly. For all other witnesses, I ask that you state your full name, position, title and agency, and swear either an oath or an affirmation. The words of both the oath and the affirmation are on the cards in front of the table before you. According to my list here, Ms Monique Hitter, would you like to start, please?
Thank you. Monique Hitter, Acting CEO of Legal Aid New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms Catherine Boyd.
Thank you. Catherine Boyd, Deputy Secretary General Counsel at the Department of Premier and Cabinet. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. We actually have everybody sworn now? Sometimes we get ring-ins that we don't know about. All right. We'll start questioning. Opposition?
Yes, thank you. Thank you, Mr Chair. Mr Attorney, you might remember last November I asked you some questions about the police prosecution of Christo Lanka. Do you remember that?
I do.
And that was in the context of a discussion about the efforts by the police to put in place a suppression order on, if we can use the term, the publication of the coverage of various political commentary about the government in relation to Mr Barilaro. You remember that?
I do.
And I think it transpired in evidence that the Crown Solicitor had given advice to the police about whether that application had reasonable prospects. And I think the evidence was that it didn't. The Crown Solicitor was a bit hesitant last time. Obviously, we don't want to get into the details of the advice given to a client. But can I ask you, Mr Attorney, I think in the transcript you said you would inquire into when the advice was given. Can you or the Crown Solicitor tell us approximately the date at which the advice was given to the police service about?
I'll invite Ms Smith to respond.
I'd have to take that on notice.
Okay. Do you think it's possible you could have inquiries made so that during the course of the day we could find out? So I might do some follow-up questions. The issue here was whether or not the police had sought the legal advice prior to making the application or subsequent. And I think it was their evidence that it was subsequent rather than beforehand. I think we agreed, Mr. Attorney, that it's always prudent to get legal advice before embarking on such a matter. I think you'd agree with that?
As a general proposition.
It was as a general proposition, that's right, yes. Now, in relation to that matter, you were also a bit hesitant to make comment because the matter was before the courts. On the 10th of March, the police withdrew the matter and agreed to pay costs. That suggests, doesn't it, that the application was unmeritorious? Would you generally agree with that?
Well, look, apart from media commentary and social media commentary, I've had no involvement in that matter. I've never received, I'll withdraw that. I have my best recollection is that I've never had a brief on the matter. I've never discussed it with any of my colleagues. I've never discussed it with the police. So apart from media reporting, I'm not au fait with the precise details of the matter. I think what you're implicitly doing now is that now that the charges have been withdrawn, inviting me to provide a commentary that I was unwilling to provide last time, I'm still unwilling to provide that commentary. I don't think it's appropriate for me as the First Law Officer to be commenting on matters where I'm not across the detail, and I'm not required to be across the detail.
Sure.
I understand impressions that can be given by withdrawing the charges, and I certainly understand the criticism of the police action in that matter. There is a suggestion that the gentleman who was the subject of that charge might take civil action. I've seen on social media suggestions that the matter may be referred to the Law Enforcement Conduct Commission. At least at the moment, while there's a live prospect of the matter going to the Law Enforcement Conduct Commission, I don't think as a member of the executive I should be giving any commentary that hints at whether the LEC should or shouldn't uphold any complaint that is made. I think that runs the risk of sort of like an improper signal to an independent body that oversights the police.
Sure. But the context of this is we have the defamation action, I think, brought by Mr. Barilaro in the federal court. Then you have, if you like, the arrest of the producer of the program that gave rise to the defamation action. And I think I was exploring with you, as the First Law Officer, the appearance that, the agents of the state, in the form of the police, appeared to have been deployed against a political critic of the government. Do you understand that criticism?
Look, I understand that criticism, but I don't think it's appropriate for me to endorse that criticism or withdraw or undermine that criticism. It may be different if and when LEC, if LEC investigates the matter and makes findings, it might be appropriate then for me to comment, just as I did last year with Operation Monza, where there had been a LEC inquiry and a LEC report, and I was willing then to offer my own disapproval of police conduct leading to that matter. But at the moment, where I think there is a live prospect that it will go to an independent commission to look at, I don't think it's appropriate for me to be giving signals to what that commission should or shouldn't find.
Okay, so you're now the minister responsible for that commission now, aren't you?
That's correct.
And that's new. You weren't the minister in November.
That's correct.
So under Section 34 of that Act, the minister can refer matters to the LEC for their review. Based on what you now know, what's in the public domain, are you sufficiently concerned about this matter to refer it to the LEC to make sure that there's public confidence?
Well, look, I will see whether any private citizen refers the matter to the LEC. I think.
You wouldn't like to get ahead of it yourself?
No, well, I think there is a fair chance that some such referral may happen. As my present view is, if that referral were to happen, then I wouldn't need to take further action. If it doesn't happen in due course, then I'll consider what's appropriate.
What's due course? Like what sort of time frame are we looking at?
We're not talking about years, we're talking about days, somewhere in between, months.
But we're not waiting for the government's response to raising the age of criminal responsibility, for example, or some of those other matters. This has got a bit more urgency attached to it.
Well, I will deal with it promptly. I don't know that it's got urgency in the sense that it's something that requires a turnaround of days.
Okay. How much money has the New South Wales government essentially had expended on this matter? You've got this police investigation, the police prosecution withdrawn. The police themselves have voluntarily, as I understand it, agreed to pay the costs in that matter. You've got the use of the court time. Do you have any sort of rough estimate about how many millions of dollars this has cost the taxpayers?
Well, I don't know. I don't. In terms of police resources, you're probably best to ask the police minister that question. I understand his appearance has been postponed.
Yes.
Ms Smith may know the extent to which Crown Solicitor resources have been allocated, and if you want me to, we can go away and work out the number of days and an hourly rate and prorate it. But I couldn't do that on the spot. In terms of court resources.
Yeah. I'd just be interested to know what is the total sort of cost to the taxpayers of New South Wales of that matter, insofar as you're able to ascertain.
Well, as I haven't participated in any way in the matter, I don't know, and I don't know, for example...
there's no personal criticism of you, Mr Attorney.
No, but I don't know, for example, now that there's been an order for costs, I think...
they were fixed, it's been fixed.
What the quantum of that will be?
$12,000.
Okay.
That was no mystery about that. It was all dealt with very quickly, I understand, in the Magistrates Court. But this whole matter arose because, according to Assistant Commissioner David Hudson, when he gave evidence to estimates, the police didn't follow their own internal processes within the fixated persons unit. Is that a matter that concerns you as the minister responsible for the police watchdog?
As the minister responsible for what?
The police watchdog, the LEC.
Well, look, again, I'll see what private citizens do in the near future, and if they don't, then I'll consider what action I should take in terms of a referral to LEC. Okay, so you're also, as the Attorney General, responsible for, if I might use the term broadly, the integrity of the legal system. You accept that? As a broad proposition.
As a broad proposition. Are you concerned about what this matter has to say about the integrity of that process, about how, you know, the police have apparently embarked on this matter without perhaps taking legal advice, without, at least on their own conduct, having a strong case, withdrawing that matter? As I mentioned at the outset, Mr Searle, I haven't been involved in the matter. My best recollection is I've never been briefed about the matter, but obviously I've read commentary in media and I've heard the evidence here last time and your questions last time and Mr Shoebridge's questions last time. So look, that's something I will look at, but it may be that a private citizen might bring a complaint in the meantime. Okay. I think we established that as a general proposition, as the Attorney General, you're responsible for the integrity of the court system. You accept that as a general proposition? As a broad proposition. It doesn't mean, though, that operationally, where, for example, over 300,000 criminal cases go through the local court every year, that I can be looking at the integrity of each and every matter. Obviously, there's a degree of delegation and broad oversight. Yeah, but obviously, where matters come to your attention, if they're sufficiently serious, you might take an interest. Depending on the circumstances, yes. Yeah. Now, one of those aspects of integrity is about the giving of evidence in court. It's a criminal offence, isn't it, to interfere with a witness or to try and procure certain evidence, or to essentially broadly speaking, yes, to coach witnesses. Correct. That's correct. And that's 323 of the Crimes Act, I think. In relation to, and you're also as the attorney, although they're an independent body, you're also the minister responsible for the DPP, aren't you? That's correct. Are you aware of another matter involving the Police Fixated Persons Unit, a prosecution brought by the DPP on the advice of the police, I think? That was broadcast last night involving Police Fixated Persons Unit? Oh, look, I've seen briefly in my skimming of
media clippings this morning, there's something that I've seen a reference to a matter.
Yeah. We've got some video here I might play for you. Is that okay with you?
If you'd like me to watch it.
Okay, if we might just play the video with the sound down. I don't think it's required. It should come up on the screen, Mr. Attorney.
Thank you.
Now, this is all in the public domain.
Yep.
So this is proceeding inside a courtroom. It's from the court CCTV. Down the bottom, you can see the police officer making signals to the witness, catching the witness's eye. This is a second witness, also catching the officer's eye, causing the lawyer to turn around. Obviously, there's some things going on in the courtroom here. Subsequently, we've got the officer talking to people who haven't yet given evidence. He seems to be doing all of or most of the talking. That's the same footage. So
Can I just interpose,
Of course you can.
Mr.
Pause,
Mr.
pause
Searle?
there.
I'm not sure whether it is a contravention of the Court Security Act for you to be playing this from CCTV. I'm not saying it is or isn't.
I don't
but
think it is.
Me sitting here and nodding my head is not acquiescence
No, I understand
in
that.
any legal contravention
No,
that
this
may or
is-
may not be taking place.
My understanding is this is covered by parliamentary privilege. This is a proceeding.
Covered
of
by
Parliament.
parliamentary privilege.
Okay.
Yeah, and we have seen the police charge in and arrest people with no notice, though,
Okay.
in those circumstances.
Anyway, Mr.
Threatening that, are you, the
Mr.
attorney?
Shivridge, I'm asking the questions. So here you can see a police officer sending a text message. We don't know to whom or about what. Keep playing, please. And then someone who's a witness outside diving into their bag. Obviously, you know, looks like they might have heard their mobile phone go off. And this is the witness, the key witness giving evidence. And that's subsequently the police officer subsequently talking to people who have yet to give evidence. So something's going on in the courtroom, and then the officer subsequently goes and talks to people.
And a bit.
Okay. Anyway, I think that's essentially you get the sense of it, Mr. Attorney. Now, I believe that's the same officer that was involved in the arrest of Christo Lenker. Now, that was a matter that seems ill-conceived, and the police have withdrawn that. This was a matter also brought by the Fixated Persons Unit. There was a conviction in that matter, but it was subsequently overturned by the District Court on the basis of insufficiency of police investigation, not on any other basis. But there does seem to have been, at least in passing, if you read the judgment at paragraph 14, a query over the credit of the evidence, if I can put it neutrally like that. Having seen that, as the Minister responsible for the prosecution service that brought that prosecution on the advice of the police, and seeing the involvement of that same officer involved in the other matter we were discussing, are you now sufficiently concerned about the possible interference with the integrity of that proceeding to refer this to the Law Enforcement Conduct Commission, or do you need to consider that?
I'd need to consider that further.
Okay. But it's something you will consider now?
Well, now that you've raised it, I will consider that.
Okay.
It's not clear from that video. Well, obviously,
No, it's not.
we haven't got any sound, so I don't know what the officer was saying to the person outside.
Agreed.
And the witness, I think you're suggesting that at the same time as he's texting something, she is looking at her phone.
It looks that way.
Yeah.
It looks like he sends a text to someone, she hears something go off in her bag, possibly her mobile phone message being received. But it does look, when you review the material, at least it looks to me, like there is coaching of evidence, including catching the eye of two witnesses in the witness box.
Well, look, obviously, it is grossly improper to coach a witness. I, to be honest, can't tell from that video that that's happened, but I'll give that further consideration.
Okay, but now that you're aware of it, it is something that potentially concerns you as the minister responsible for.
Well, it's something that I'll give further consideration to.
Okay, but you'd agree that it's important for the public to be able to have confidence in the integrity of evidence given in particularly criminal prosecutions, but all court proceedings?
Absolutely. It's critical that there is confidence in the integrity of the criminal justice process, and that includes that witnesses are telling the truth without interference.
Yeah, and there's a reason why witnesses, particularly in criminal matters, wait outside the courtroom while earlier witnesses give evidence, isn't there? That's
right. So typically a witness won't go into court until they've given their evidence, so that their evidence isn't coloured by watching what other witnesses are saying or doing in court.
Yeah, and it would be an interference with that general proposition if somebody were to be briefing witnesses about what had happened in court.
Well, that's right. I mean, it's not improper, for example, for someone to tell a witness. In fact, it's what you should do. Tell a witness that you will go in the witness box. You'll be sworn in. Your counsel might ask you a few questions, and then counsel on the other side will cross-examine you. Mm-hmm. It's not improper to find out, what the witness is likely to say. Get their witness statement.
Proof of evidence.
Yeah, proof of evidence, as you'd know, but. Obviously, it's improper for witnesses to be colluding or for coaching to be taking place.
Yeah, and where that happens, if that's if it's the case that's happened, that's a concern, and if it's the case that involves the police, in this particular instance, if that was to be the case, that would also be a matter of concern.
Yeah, if hypothetically there were that coaching, then it's a concern, and if hypothetically it's coaching by the police, well, then that would make it worse.
And that would be a matter if you were satisfied of that. That is a matter you would refer to the LEC, or would you wait for a member of the public to make that concern?
I'd see whether a member of the public were doing it, but I wouldn't be waiting for a long time.
Now that you're aware of this matter, is it something that you will evaluate expeditiously?
It's something I will evaluate. Well, I will get advice on promptly.
Okay, thank you very much. I think those are my questions
For the moment.
Yep.
Nice to see you, Attorney. And
likewise,
again,
thank you.
This is the budget estimates hearing that will not end. I think this is the third round. So welcome back.
Thank you.
Attorney, going back to the Kristen Lenker matter, we know that the state of New South Wales, through the police, has had to pay at least $12,000 in costs to Mr. Lenker for the legal expenses that he's incurred. We know that it was an appalling allegation to make against somebody that they engaged in the crime of stalking when there was never sufficient evidence for the police to proceed with that. Are you saying that after an incident like that, where the charges have been withdrawn, a substantial amount of public money is paid over to the defendant for a case that should never have been brought, that there's no systemic review of it? Your department does no systemic review. Is that what you're saying?
Well, I don't as Attorney General. I was asked a question by Mr. Searle about the integrity of the legal system. Given there are hundreds of thousands of cases that come to court every year, I in my office don't have the resources to be looking at every case that has come to court. If charges have been withdrawn...
Clear,
hang on,
we're not talking about every case.
I haven't finished my answer. If charges have been withdrawn, then you would think that means that police don't think they can prove their case. Whether or not the case should have ever been brought in those circumstances is not something that I, as an outsider at the moment, can opine on. And I'd expect that if a private citizen has a complaint about that, they will take it to LEC, and if they don't, then I'll consider what I may do.
Well, LEC has no oversight of the courts. That's not LEC's job.
Well,
LEC has no oversight of proceedings in courts. That's your job, Attorney.
Well, the implication here is that, I'll just be clear, the suggestion you might be making is that the police have acted improperly in this matter. That is not any reflection on the court. That's a question of police action. I anticipate the fair chance that a private citizen will make some sort of complaint about that to LEC. So at the moment, I will wait and see what happens in that respect. But it's not a court oversight matter. It's a police oversight matter. Because no evidence was ultimately led in the court, and the court was not required to make a determination.
No, but it was on the initiative of the court that admittedly commenced by the police, but it was the court that effectively initiated it was the court proceedings and the power of the court that compelled Mr. Lanka to be there and to incur the legal costs. I don't understand why there isn't a process in the Attorney General's Department to at least do a basic review when the courts on the face of it have been abused like this by another government agency. Because if we're just relying on police investigating police, nothing will happen.
Well, look, if there's been an abusive process by the police, you've got an independent law enforcement conduct commission there to oversee that. You've also got independent courts that, if the matter goes far enough, can make findings about an abusive process. A litigant can contend in court that something is an abusive process. So when you have courts potentially dealing with that issue, when you have an independent police oversight body dealing with that issue, you don't need a politician and his staffers, or indeed his department, overseeing that as well. You've got two independent oversight mechanisms already. The courts, if a matter progresses far enough, on the one hand, and the Law Enforcement Conduct Commission on the other hand.
So in this case, it was simply a matter of accidental good fortune that Mr. Lanka managed to have sufficient resources to fully test the police case and challenge it in court. Now, he just may have enough resources to bring another civil case at yet more expense to try and vindicate his rights. But are you saying for those people who don't have those resources, and they're not able to bring a civil case, that there's just nothing?
No.
Your
not
department
at all.
won't do anything because you're saying it's up to them to challenge an organisation as powerful as the New South Wales Police?
No, I'm just saying there is a taxpayer-funded Law Enforcement Conduct Commission that is independent of government, that can receive complaints from the members of the public without any need for vetting or imprimatur from the executive. So there is a mechanism there. I take your point about civil proceedings and that, unfortunately, typically you need deep pockets to bring civil proceedings. I take that point. But so far as police oversight is concerned by the Law Enforcement Conduct Commission, you don't need a deep pocket to make that complaint.
You know that the Law Enforcement Conduct Commission investigates a fraction of the complaints. It's, I think, 2 or 3% of the complaints it receives because it simply doesn't have funding to investigate more than 2 or 3% of the complaints. You know that, don't you, Attorney?
Well, I don't know that. It may well be.
Well, you're the minister responsible.
Hang on, I haven't finished my answer. I don't know that. It may be that only a minority of complaints are investigated, but LEC would also have a vetting mechanism where if they don't think a complaint is sufficiently serious or well-grounded, they won't pursue it. But if a complaint is made in this case, then I don't want to hint what LEC might do, but there's no reason to think LEC won't look at it.
Well, you challenge my proposition that it's only a tiny fraction of the cases that are referred, the complaints that are referred to LEC that are investigated. If it's not 2 or 3%, let me finish. If it's not 2 or 3%, what percentage of complaints end up being fully investigated by the LEC?
I'll have to take the percentage on notice. I didn't challenge your proposition that only a small percentage end up being fully investigated. What I did challenge was the suggestion that it is a resourcing issue as distinct from filtering by LEC to work out what cases it considers are worthy of investigation and what cases are either well-grounded or not sufficiently serious that warrant its attention.
Well, the LEC has made it clear in its annual reports that it has insufficient funds to do the tasks which it's been assigned. It's said that in its own annual reports. You're not challenging that conclusion from the LEC, are you?
Well, the LEC and other integrity agencies at the moment have been consulted by government about what their baseline funding should be going forward. As you know, there have been parliamentary inquiries and an Auditor General's report about funding of integrity agencies, and that's something the government is looking at in the next budget.
Attorney, you've just seen a small part of the video evidence from the more recent trial, where the actions of an officer who was one of the primary movers in the Christo-Lanka prosecution, again is engaging in actions which, on the face of it, appears to be highly problematic. You don't think that those facts together should motivate you to commence some investigation of what's going on in the courts?
Well, I'll give that consideration. It wasn't entirely clear to me watching that video just exactly what happened. The fact that a policeman is speaking to witnesses outside court, unless you know what he's saying, what they're saying back and what it's about, you can't necessarily jump to conclusions. The fact that someone in the witness box picks up their phone, I can't. I
don't think
can't,
that wasn't in the witness box. That wasn't in the witness box.
Well, I can't sitting here jump to conclusions and join the dots. Now, I want to be very clear that if there is any coaching, I'm not excusing that, and I'm not saying it did or didn't happen. I just can't tell from that video what happened. And as I said, I'll give the matter further consideration. But on the basis of a video without sound, sitting here, I'm not going to jump to conclusions right now.
Well, Attorney, I'm not asking you to form a conclusion, but I am going to ask you whether or not you'd be willing to look at the very lengthy video, which you only saw a small fraction of, where the officer repeatedly comes out of the court and repeatedly speaks to witnesses waiting as the evidence is unfolding in court. Now, will you seek a review within your department of the evidence that shows that repeated behaviour by the officer?
I will get advice from the department.
And can I indicate the behaviour is particularly troubling because the officer appears to be repeating hand movements indicating critical elements of the case as given by witnesses and as conveyed by counsel in the course of the proceedings. That I accept, as you say, we can't draw conclusions from what's there, but I would suggest to you, and I'd ask if you agree, there is sufficient there to commence an investigation.
Well, look, I can't agree or disagree. There is insufficient there to form a conclusion, but you're not putting that to me. You're saying, will I investigate? I will get advice.
All right. Last time we spoke, Minister, about another example of what was unquestionably gross police behaviour involving court proceedings, which were the conclusions in Operation Monza, where the police intentionally and deliberately harassed a solicitor on the way to court, which was the finding of the Law Enforcement Conduct Commission. You said you were seeking advice from the police themselves about whether or not they would take any action. Well, it's now the better part of 12 months since that report was delivered. What advice have you received from police?
So I think I reported last time that I'd asked the then Police Commissioner what, if any, action he proposed to take. He wrote back to me to say that he wasn't taking any reviewable action, I think it's called. LEC had recommended that the Police Commissioner look at doing that. Reviewable action, I think, is action that can be reviewed by the Industrial Relations Commission. The Police Commissioner, and I'm paraphrasing loosely, told me in writing that he wasn't going to do that. He had, I think they had been admonished or some such thing. The view I take is that it is fundamental that any participant in the legal system not be the subject of harassment for doing their job. And that extends not just to judicial officers, it also extends to lawyers. Defence lawyers play a vital role in our criminal justice system in terms of fair representation. it is not good enough that if police have a gripe against the clients, that they implement that gripe by harassing lawyers. Might I say that Strikeforce Raptor and the police generally do a fantastic job, but on this occasion they let themselves down. I think it's important that our legal processes stand up for defence lawyers and the integrity of the legal system in this respect. So that's why I am consulting on extending other provisions of the Crimes Act that Mr Searle didn't mention earlier to cover defence lawyers. The protection that is given against interference to judicial officers, for example, extends to defence lawyers.
So a senior officer in Strikeforce Raptor plans an operation with other police officers at public expense to camp outside a solicitor's office on his way to court to defend a matter brought by Strikeforce Raptor. They intentionally and deliberately harass him repeatedly on the morning before going to court. They engage in intimidatory action outside his office on his way to court. He's so fearful of his position that he tells the magistrate he can't proceed on the day because he's frightened by what happens to him. And the outcome from the legal system is the police commissioner has determined to admonish those officers. No charges, no fines, no serious action. They get an admonishment. That's the outcome, is it?
Well, that has been the outcome, and in my view, given the recommendations of LEC that have not been implemented, I'm now looking at reform to the Crimes Act so that someone in those circumstances has the protection of the criminal law.
That seems a sensible step forward, and I'd urge you to bring that legislation forward as soon as possible. But interference in the administration of justice is a criminal offence. Contempt of court is a serious criminal matter. Why have neither of those options been considered by you and your department, given the police in this case intentionally planned to intimidate a solicitor on his way to court in a case against themselves?
Yep. I don't know what consideration has been given to criminal charges. I did get a brief about the matter and whether it would rise to the level of the section of the Crimes Act that Mr Searle referred to,
323.
Perverting the course of justice. I don't want to waive privilege over that advice.
I'm not asking you to.
But having received that advice, I don't think it would be a productive use of resources to prosecute. In the event, of course, I'm not a prosecuting authority. I don't have the resources to prosecute. The DPP also, while they're a prosecuting authority, they have to rely upon a brief from police. But having taken some preliminary advice on the matter, I don't think a prosecution here would have sufficient prospects of success to be worth bringing.
Well, Attorney, a key reason for that is the police have refused to investigate it. They haven't even commenced disciplinary action, let alone referred the matter off for a criminal investigation. We often talk about the failures of police investigating police. This is even worse. This is police refusing to investigate police, and you're saying because there's no evidence there, despite gross and obvious malfeasance by the police, if they refuse to gather evidence about themselves, it's a dead letter. Nothing can happen.
I didn't say that. I said the police elected, or the commissioner elected, not to take disciplinary action of a reviewable kind, for example, a dismissal or a demotion or a suspension, but some kind of admonishment or something like that. I don't know what consideration police have given to bringing charges. I mean, it's a fair inference. No, I'll draw that. I don't know what, but I in a brief had some preliminary advice that I don't want to waive privilege over, but having seen that advice, I don't think a prosecution would be successful.
But that advice was in the absence of any brief of evidence or of any investigation, because as you point out, Attorney, it's not your department's job to investigate. In this case, it's the police's job to investigate.
Well-
So what happens here? Is there just a big justice hole that these matters fall into?
No, I don't think so. There's an internal affairs unit, an internal disciplinary unit in the police. In terms of fact-finding...
But that's subject to the direction of the Commissioner.
Hang on,
who's
but
already
in
said
terms of
nothing's
fact-finding,
happening.
the advice that I received was based on the facts as found by the Law Enforcement Conduct Commission. So that advice didn't require a lot of further fact-finding. There had been findings of fact by LEC on which that advice was based and on which LEC's recommendation to the Commissioner was based. So even if the police had not investigated the matter, LEC had investigated the matter, and LEC did not recommend, having found those facts, LEC did not recommend the bringing of criminal charges. It recommended disciplinary action, but it did not recommend the bringing of criminal charges. And what I've said in these circumstances, where having taken advice, it didn't seem that a prosecution was successful, and no disciplinary action being taken here. I'm not seeking to retrospectively bring criminal proceedings here, but I want to consult on filling what appears to be a gap in the law, bearing in mind it may not just be as simple as inserting defence lawyer or lawyer into a definition of whatever it is, legal officer, because it may be in some circumstances that a retribution against a lawyer should not be criminalised. For example, if a client is unhappy that his or her lawyer is representing somebody else, they may say, well, I'm sacking you as my lawyer because of action that someone has taken in a proceeding. So there may be circumstances where you don't want to criminalise across the board threats or retribution by someone against a lawyer. But in a case like this, a defence lawyer who is doing their job shouldn't be harassed or intimidated, notwithstanding what the police think of their client. And as I said before, the overwhelming majority of the cases, police do a fantastic job, but on this occasion, they let themselves down, and the community.
Attorney, will you table the written response you got from the Police Commissioner?
Yes, certainly. I don't have it here, but I
If
certainly
you
make
can table it
available.
at some point today, that would be appreciated. Did you seek advice on whether or not the actions of the senior officer and other officers from Strike Force Raptor was potentially a contempt of court and actionable as contempt of court?
I don't believe so. My best recollection is I didn't.
Can you provide any further detail about that on notice?
Certainly.
Attorney? What is the timetable for filling this gap in the law?
Well, this year.
Right.
Subject to consultation and subject to cabinet approval, but as I say, that in principle there is a gap to be filled. But as I gave an illustration of where an across the board criminalisation of some kind of retribution would not be appropriate, and that's a matter of getting the drafting right.
I'm not pushing back on that. I accept that there's a drafting challenge there. Attorney, unless I've missed it, has anybody been appointed as the Modern Slavery Commissioner yet?
Mr McKnight, who sits to my right, is the acting commissioner, and a recruitment process is in place, and we should have a permanent commissioner by about April or May. Is that correct?
I hope so.
So interviews have happened?
No, the ad for the job is out at the moment, and it closes in a week or so.
All right, and there's the time frame that you're working on, Mr McKnight, is...
As soon as possible.
And with a end date at the end of May, is that the kind of time frame you're
I would
looking
hope
at?
to reach that target, yes.
Thank you, Chair, and Attorney, welcome.
Morning.
Good morning, everybody. Attorney, I'll take you to the matter of the child sex offender list referral to New South Wales Law Report Commission. In 2019, the LEC, the Law Enforcement Conduct Commission, released a report into the management of the Child Protection Register. Under the Child Protection Offenders Registration Act 2000, You know the story. The Commission found that since 2001, there's been hundreds and hundreds of errors. New South Wales Police Force had made over 700 errors, in fact, according to the report. There have been many breaches, child sex offenders being in the community unmonitored, widespread unlawful use of intrusive powers under the Act. For those reasons, the Commission recommended that the New South Wales Government urgently refer the CPOR Act, and in supplementary report issued this year, the Commission reiterated the reform was imperative and that substantial errors would continue to be made until the Act is reformed. Minister, the question is, why have you allowed this serious situation to fester unresolved?
So I don't have responsibility for this register. There was a recommendation that I refer reform of this register to the Law Reform Commission as Attorney General. I have not taken up that recommendation. At the moment, I currently don't intend to take up that recommendation. Police and the local court, among others, have been working on a regime to deal with the problems that you've identified, and that work is still underway. And I'm not. Well, at the end of the day, I don't have portfolio responsibility for the register, but to the extent that I've been named in a report as someone who ought to refer it to the Law Reform Commission, at the moment, I have informed the view that all reasonable possibilities of that police work have been exhausted, and we should take some different approach.
Well, has that changed?
When once it goes to the Law Reform Commission, that's another year or two or more of consultation and report. Notwithstanding the extensive delay that has happened, I think there is still a better prospect of an expeditious outcome with police working on it with the courts than me sending it off almost to start all over again with the Law Reform Commission.
Well, Mr. Attorney,
has that changed since November last year? I mean, in November budget estimates, you said that you don't intend to refer to the Law Reform Commission, and that you'd regard that as blocking. It's not blocking me referring to the Law Commission, but rather me giving them the opportunity to develop a proposal. I certainly hope that there will be legislation next year. So it seems to be under your domain, wasn't it?
Well, no. As I said, I was named as so I've got portfolio responsibility for the Law Reform Commission, which was why I suggested I should refer the matter to the LRC. I don't have portfolio responsibility for this register. My understanding is work by the police and others is still underway. And I'm not saying I'm not ruling out entirely that I may not refer it to the Law Reform Commission, but at the moment, the best prospects for an outcome for the police and others to continue that work.
well, Mr. Attorney, I think last November, I might have put it to you that Minister Elliott was and the police were blocking you from doing so, and you said, I think it was your evidence, no, look, I think a better view is I'm giving them the opportunity to address the issue.
Yeah.
It's now been nearly 5 months. I note what you say about delays of matters that go to the LRC. Sometimes it's the graveyard of law reform. Not always, though. But we've already lost half a year, just about.
Yeah.
At what point in time would you form the view, look, the police aren't being serious here, or they're not going to come up with the goods, and this matter ought to be looked at by the LRC?
Well, I certainly haven't formed that view, and I'm nowhere near forming that view. I think, to my observation, the police have genuinely tried to solve this problem and are still working hard at doing that.
And do you still expect legislation this year to be in the Parliament?
That is the aim. That is the aim.
Thank you, Minister. Attorney, it's clear that the LEC wants it referred to the Law Reform Commission, and the police wants it referred to for a legislative reform process. So there seems to be a toing and froing between the various organisations, but there's no resolution of this matter. Is the government going to take steps to resolve this issue?
Well,
Attorney?
in one sense, my only role is whether or not to refer it to the Law Reform Commission. Everything else, it's the portfolio responsibility of the Police Minister. So there's only so far I can take it in answering your questions.
Well, Minister, because the reason I ask as well is that the report clearly indicates that there's serious risk to children as a result of the failure to resolve in this issue. I mean, as the attorney, as the first officer of the state, you'd have some responsibility of pushing to resolve this issue to ensure that that children are not facing potential threats and have significant concerns, as the various reports have mentioned.
Well, look, obviously I want to see an expeditious and appropriate outcome. Even as Attorney General, one of my priorities has been dealing with child sex abuse, which is why we've implemented the overwhelming majority of recommendations of the law reform, of the Royal Commission into Institutional Responses to Child Sexual Abuse. It's why last year we introduced legislation to reform the ability of past claimants to set aside unfair judgment. So we have been extremely active in this area. This niche, though, of child sex abuse sits with the Police Minister. My narrow remit is to decide whether or not to refer it to the Law Reform Commission. At the moment, I'm not going to do that because there's a pretty good prospect that the police and the courts and others will come up with a solution that addresses the significant concerns that you've highlighted.
When do you expect the police will come up with those solutions?
Well, I'm not the Police Minister or the Police Commissioner, but if we don't, the aim, I think the aim of government is to get it resolved sooner rather than later. I personally, as a Cabinet Minister, would be disappointed if we haven't fixed it up this year.
Because it's been going on for around 2 years or perhaps more, Minister.
That's right. But I mean, it's a bit like, I think there's a analogy of an Irishman who says, who's asked, how do you get to Dublin? And he says, well, if I wouldn't start here. If 2 years ago we knew where we'd be now, we might have done things differently. But we are where we are, and the most expeditious way forward, from my viewpoint as the non-portfolio minister, is to have the police continue to work with the courts and others to come up with a solution rather than referring the matter to the Law Reform Commission.
Will you be speaking to the Police Minister about resolving this?
Periodically I have discussions with the Police Minister about a whole range of matters, and this will be one of them.
Well, just on that, I mean, you accept that there's a crisis in the legislation, don't you?
There are problems with the legislation that need fixing.
Okay, well, more than problems. The LEC has issued not one but two reports saying that urgent changes are needed. You've got a situation where some people who aren't on the register
It's that one up there.
should be, and you've got potential predators, not on the register. You've got apparently people on the register who shouldn't be. That's a gross miscarriage of justice for those people. And there's over 700 instances that have been charted. When I read the LEC reports, there was a sort of a sense of urgency, a sense of crisis. Do you think the police accept that there is a real urgency for this reform?
Oh, I think so. I mean, it's unacceptable that you have false negatives and false positives and other errors in something as serious as a child sex offenders register. So I'm confident they understand the gravity of the issue and the need for an expeditious outcome.
Okay, and notwithstanding that you're not the portfolio minister, we accept that, but nevertheless, you are a minister, the attorney, who could do something, albeit, maybe not as quickly as others would want. But if we get to the middle of this year, the chances for legislation, surely the window for that would be closing pretty quickly.
Oh, it depends how difficult you are in the upper house, Mr. Searle. But
I think as you found with the public interest disclosure legislation,
we can be very cooperative.
We can be very cooperative, Mr. Attorney. So could you perhaps take on notice, maybe confer with the Police Minister and give us the sort of your best estimate of when we could expect something on this?
Certainly.
Okay, thank you.
You did say you were hopeful last November that you would have legislation this year, Minister.
Well, that's right.
And you're still hopeful?
I'm still hopeful.
He's an optimistic kind of guy. Is that right, Mr. Attorney?
The bottle half full, not the bottle half empty.
Indeed.
Minister, with regards to the Special Commission for Inquiry into Drug Eyes, the Dan Howard report handed down in January 2021, your government ruled out 5 key recommendations and promised to consider the balance of the report. 25 months later, and still no formal response from your government. In the last estimates in November, that's 6 months ago, you said you said regarding a time frame that good things come to those who wait. Minister, why the lack of response in this space?
Thanks. Well, I think I said last November, if it hadn't been sorted out by Christmas, I'd be disappointed.
You must be very disappointed.
It wasn't sorted out by Christmas, and I am disappointed. And I'll be disappointed if it's not sorted out in the near future. There are over 100 recommendations for us to consider. The government has been looking at those very, very closely. I am disappointed that we have not made a full response yet. I'm continuing to work very hard on getting that response out, bearing in mind that most of the recommendations are health recommendations, they're not law reform recommendations, so most of it is outside my portfolio. We have announced the drug court in Dubbo, so there is some progress there. The Walama list is now starting in the district court, so there is progress there. So it's not as though nothing has happened, but I am disappointed that we haven't been in a position to make a full announcement, and I'm hopeful that'll be sooner rather than later. I remain very ambitious about this response. I think I've made my position crystal clear that we need a rethink on our approach to drugs. Whatever fantastic job the police do, they are just scratching the surface when they confiscate drugs that are being imported. We've had that evidence before the ICE inquiry. There is no point throwing people with a substance abuse problem in jail and throwing away the key. We need to concentrate on diversion. What form that diversion takes, whether it's pre-court or post-court or some combination of the two, is a matter for Cabinet and debate within Cabinet. But it is pretty clear that a lot of diversion cuts reoffending. The drug court has been an outstanding success. As I say, I remain ambitious not to normalise drug use, not to retreat, but to make sure that our taxpayer-funded interventions are actually having some effect. We know from federal statistics that typically in the last 12 months, 1 in 7 Australian males in their 20s has used cocaine. So the idea that this is just some kind of a small group of marginalised substance abusers is totally wrong. And that's why we need a whole-of-government response. I've only got portfolio responsibility for the legal side of things. Overwhelmingly, it's a health response. I am confident we will get a good result. What the precise metrics of that will be is still subject to internal discussion, but I'm confident we're going to get a good result. I'm confident we're going to do more on diversion. What we will do will be a matter for debate within Cabinet and taking expert advice, but I'm confident we'll get somewhere.
We know for a fact, Minister Attorney, that the household drug and alcohol use has increased during the lockdown, and apparently there was a significant increase, in particular with the use of ice. What's your reports on that, given those circumstances, and what steps are you taking?
About what?
On this issue that there's an increase in the use of ice.
Well, if there's an increase in the use of ice, that's a health issue. It's not a legal issue. And so far as that adds to the whole matrix of reform in this area, we know the effect ice has on families and on users. Destroys relationships. People lose their kids, they lose their homes, they lose their partners, they lose their jobs. We know what misery it causes, but it doesn't follow that locking people up is going to solve their problem. And that's why our approach has to be not one of retreat, but one of intervention, but intervention that has a factual basis for it. So the point you raised just is yet another dimension to the overall problem.
Mr. Your government ruled out 5 key recommendations, and there's been questions asked as to what were the reasonings behind rejecting the 5 key recommendations, or the 5 recommendations. For example, recommendation 11, that in conjunction with increased resourcing of special drug assessment and treatment services, the New South Wales government implement a model for the decriminalisation of the use and possession for personal use of prohibited drugs. What was the reasoning behind your government rejecting this recommendation, for example?
Well, when you've got more than 20 cabinet ministers making that, you might have 20 different reasons. But I think I could crystallise it this way. There is the risk, if you decriminalise, that you are normalising drug use. Now, many people will disagree with that, but there is the risk that that's the message you're conveying. I know Don Weatherburn, for example, the former head of Boxar, has suggested that you would see an increase in the number of users if you decriminalise. So we've ruled that out, but we have not ruled out other diversion, pre-court or court diversion, to recognise that at the end of the day, drug use it's a health issue, and people use drugs for a whole variety of reasons, but they don't choose to or not use drugs because of a criminal law process. So we are looking at, aside from criminalisation, decriminalisation, what else we can do in the diversion space.
What is your reasoning as well in relation to Recommendation 51, that the Drug Misuse and Trafficking Act 85, New South Wales, be amended to provide for supervised drug consumption services to be provided based on local need, and that pregnant women be eligible to access drug consumption rooms as clinically advised?
Well, Cabinet has made a decision, so that's a form of diversion. And you could look at decriminalisation as a kind of form of diversion.
But this was
as
rejected
well.
by...
That one was rejected because Cabinet formed the view that it may send the wrong signal about drug use.
What about your view as the first...
Well, I don't have the liberty of personal views when Cabinet makes a decision. I support all Cabinet decisions as a member of Cabinet. And what I'm enthusiastic about are the other types of diversion that we are looking at, pre-court and court diversion. Not just the idea of infringement notices that the Police Commissioner has supported. So, we're at music festivals, we've got a scheme now of infringement notices, which, at least when it started, appear to be generally accepted. Of course, we've had a hiatus in music festivals over the last couple of years with COVID, but there was general acceptance of that, where offenders got a $400 fine and an infringement notice, rather than go to court, rather than getting a criminal record. We know that Indigenous diversion programs like circle sentencing work. There's a recommendation there about the Youth Curie Court. We're taking up a Walama pilot. So there's a whole host of things we can do apart from medically supervised injecting rooms that have good prospects for diverting people from drug use.
What about the Recommendation 80, that the New South Wales Police Force cease the use of drug detection dogs at musical festivals and implement other detection practices to target illicit drug supply?
Well, we've rejected that because on police advice, the use of that technique is an important part of detecting offenders.
Just going back to the Recommendation 51, with regards to pregnant women be eligible to access drug consumption, you said that the Cabinet rejected it, but you saw it as a potential diversion.
No, I didn't say that. I said Cabinet rejected it, and I said as a member of Cabinet, I support all Cabinet decisions.
Well, what's your view on that one?
Well, again, as a member of Cabinet, I support all Cabinet decisions, but my view is that generally diversion is more important than criminal sanction, and that's why, as a government, we're looking actively at forms of diversion, but what matrix that will take, the design will look like is still a matter of rigorous internal analysis.
Is the term analysis or debate?
I'll ask the
Well,
formal...
both. When you analyse something, you see the pros and cons of action, and you debate those pros and cons and reach an outcome.
One final question before I hand over to my colleague. With regards to Recommendation 97, that the New South Wales Government pilot and have independently evaluated a needle and syringe program in one or more custodial facilities in New South Wales. Why was that rejected? What's the reasoning behind it?
Again, it's a Cabinet decision, and I support all Cabinet decisions. But there's a question there of the risk to corrections officers if there's a needle exchange program. That's the rationale for rejecting it.
You said, I think, at the last estimates that if there wasn't something by Christmas, you'd be disappointed. Now, I guess to be fair to you, you didn't specify which Christmas. But do you really think there's some prospects for action in the balance of this year, before this Parliament expires?
Absolutely, absolutely. Look, I said I'd be disappointed, and I am disappointed. I am ambitious, and I remain ambitious. Now, what that will look like will be the subject of analysis, or, to take Mr. Shoeridge's point, debate. But I'm confident that we will land somewhere which, whether it's perfect, whether it goes as far as people would like, or goes further than some people would like, I think we will end up with a pretty good landing.
Sure. Now, without revealing, obviously, deliberations within Cabinet, are you able to indicate what the causes of the delay are? Is it this debate and analysis that you've referred to, or is there some other logistical? Is it budgetary? Is it a policy discussion?
Well, I can certainly rule out that it's a budgetary issue.
Okay, well, that's
I can rule that out. Although there will obviously be, there are obviously budgetary implications for some of these decisions. I mean, the diversion costs money, but chances are the diversion costs a lot less money than incarceration.
Yep. Thank you.
So it's not budgetary decisions, it's policy decisions, it's evaluating the evidence and landing at a place that is in the interests of drug users, reducing their harm, getting them off drugs, and in the interests of the safety of the general public.
Yep. There's another way of saying diversion costs money, but less than incarceration. The other way of saying it is, isn't it, Attorney, that diversion saves money and allows resources to be spent on helping people rather than punishing them for addiction?
You could say that, and there's a lot of merit in saying that, and that's we know that, for example, the drug court is a cost-effective way of dealing with drug addiction issues, and the money you spend on intensive programs for drug users who have offended ends up being saved in the long run by the further crime you avoid, the housing cost you avoid, the unemployment benefits you've got to pay. So, diversion can save money, but of course you can't just speak in the abstract. It's got to be the right sort of diversion, and you've got to make sure that any diversion program we embark on is empirically tested. To show that its particular design is the best design you can have and it produces results.
Attorney, the ICE inquiry was handed down, I think, delivered to your government in January 2020.
Correct.
We're now more than 2 years and 2 months after, and we haven't seen a coherent response from your government other than to reject a subset of recommendations. Do you accept that that's an evidence of your government failing to live up to the promise that the former Premier made when the inquiry was established?
Well, I'm not sure what promise she made in terms of timing. There's obviously a
promise to do something. The promise wasn't to have an inquiry and let it end there. The promise was to have an inquiry, then implement their recommendations.
Well, I think last time you asked me how much did the inquiry cost, and I think I said over $10 million.
I think it's 11 million.
11 million. We haven't spent that sort of money to have a detailed expert report that took an enormous amount of evidence from experts just sit on the shelf. We intend to act. I'm disappointed that we have not been in a position to provide our comprehensive response. But I can tell you that below the surface, there's a lot of furious paddling going on to get there, and we've already announced our response on the drug court in Dubbo, the Walama list, and there's more to come.
Well, Attorney, none of the key recommendations from the ICE report have been fully implemented, and I think last time I checked, about 95% of them haven't even been touched by your government. That does rather look like spending $11 million to have a fancy-looking report on the shelf, doesn't it?
Well, if the end result is the report just sits there and goes nowhere, that would be valid criticism. I understand the criticism about delay, but I'm confident that we will get a good landing place.
Attorney, there's been a recent number of cases where the state of New South Wales, in defence of historic child sexual abuse matters, where the abuse predates the 28th of October 1983, which was when a key reform to the law reform, which was when the Law Reform Vicarious Liability Act came into play. There have been a number of cases now where the state of New South Wales has pleaded the fact that for abuse that predates 1983, October 1983, the Crown is not vicariously liable for the actions of its servants. Has this concern been raised with you?
It has, by you. Yeah, you wrote to me in December, and I apologise I haven't responded to your letter yet, but I haven't had a chance to digest my brief.
I can provide you with yet more cases, if needed, where victims, persons asserting that they were victims of historic child sexual abuse before 1983, where the failures or the abuse occurred by employees or agents of the Crown, they're being told by your government that the Crown's not vicariously liable and that they have to sue those individuals personally, many of whom, of course, have deceased. Do you accept that that is wrong in principle, asserting those kinds of defences for historic child sex abuse?
I'm surprised that if that is the case, but I haven't seen. I know you've written to me. I haven't seen your correspondence, and I haven't seen the brief from the department, which I think is in my office, that advises me on the matter.
Mr. McKnight or Mr. Tibble, is anyone from the department aware of the matter?
I'm aware that we briefed the attorney, yes.
You're aware that there is that gap in the law that for, in this case, historic child sexual abuse matters, where the abuse is said to have been by an employee of the Crown, or the failure to act, the tortious action was by an employee or servant of the Crown before 1983, that the Law Reform Vicarious Liability Act doesn't extend to that conduct before the Act commenced?
I'm aware that you've raised that issue with the Attorney General. I'm not aware of any particular cases in which that's caused an issue where justice is failing to be done, but I would have to take on notice any detail around the issues that you're raising.
Well, you can start by looking at the State of New South Wales v DC, which was an unsuccessful special leave application to the High Court. And I'm more than happy to provide you other specific details. But have you sought advice on the substantive issue at play? The fact that the Law Reform Vicarious Liability Act, I think in Section 3, expressly says that it doesn't extend to conduct before the commencement of that Act.
So sitting here, I'm not able to get into the technical detail of your question. Mr. Shoebridge, perhaps I could take it on notice.
All right. Attorney, when can I expect a response to my correspondence in December?
Sorry.
When can I expect a response?
Before December?
No, I mean, you're not. We're talking here about victims of historic child sexual abuse, where the state of New South Wales is taking a legal point to defeat legitimate claims. You're not suggesting that I have to wait 12 months for a response.
Sorry, I thought you had put it to me in December.
No, I'm asking when will I get a response to my correspondence of December, where I raise these issues with your office?
Well, as promptly as possible.
Attorney, do you have the lead in the coalition for raising the age of criminal responsibility, or reviewing the campaign and the push to raise the age of criminal responsibility?
I do.
When are we going to raise the age in New South Wales?
Well, the meeting of Attorneys General in November resolved to work up a model of what raising the age to 12 would look like. and we're going through that MAG process at the moment. There's no decision in principle by the government to raise the age or not to raise the age. We're looking at what a model will look like, the attitude of other states and territories, and then make a decision. We know that the ACT is going to 14. The Northern Territory has said previously in response to a Royal Commission, I think, that they're going to 12. Queensland, before their last state election, said they wouldn't move. If there is a prospect for a harmonised approach across the country, that's something in the first instance I would want to explore, and I think that's something that other Attorneys General want to explore as well.
Well, your answer just made it clear that we already don't have that. We have the ACT going to 14, Queensland doggedly wanting to be able to still criminally prosecute 10-year-olds, and the Northern Territory saying they're potentially moving to age 12. I mean, there's already no prospects of uniform national action. I'd suggest to you that if that's what you're waiting for, Attorney, that's an excuse for New South Wales not to act, because there is no prospect of uniform national action.
I think I used the word harmonised rather than uniform. It may be that you can't get unanimity between states and territories, but it may be that there is a sufficiently large cohort of states that resolve to stay at 10 or to go to 12 or to go to 12 with carve-outs. So the prospect for harmonised action by the majority of jurisdictions is still a real prospect.
So are you saying that there is a good for justice in New South Wales to keep the prospect open of prosecuting 10-year-olds, because that will be the same law that applies in South Australia and WA? You're not suggesting that that's part of your thought matrix on this, is it? That just because WA and South Australia might want to prosecute 10-year-olds, we should too, for harmony?
Some of these criminal law approaches, we do look for a harmonised approach. WA has been leading the work in this area. They were partway preparing our report on raising the criminal age. So for the last few years, this has been tossed around at the interjurisdictional level. At the end of the day, whether we move to 12 or not move to 12, at the end of the day, it doesn't have to be harmonised, but there is an advantage in exchanging knowledge and approach between different jurisdictions. Bearing in mind in New South Wales, while understanding, perhaps just a couple of contextual things, on a maybe only 4 or 5 nights a year is a 10 or 11-year-old in a youth detention centre in New South Wales. The numbers who are detained are extremely low, and generally they are there on remand rather than having been sentenced. Typically none in a year. That's the first context. The second context is that typically you're not getting 10 and 11-year-olds committing serious offences. So they are just two contextual matters to the overall decision.
Attorney, you're quite right to point out that the number of 10 and 11-year-olds who are in custody is thankfully relatively modest in New South Wales. Do you have the numbers of 10-year-olds, the numbers of 11-year-olds, and the numbers of 12 and 13-year-olds who have had criminal charges brought against them in the last 12 months?
So that's proven. That's finalised. So this is all, which would include.
If Mr. McKnight has the details, I'm happy to get it from Mr. McKnight, if that's easiest.
No, I have a table of figures. I've got the totals down there. So, so for the 12 months to September 2021, the number of finalised criminal court appearances for 10-year-olds was 3. For 11-year-olds, 15. 12-year-olds, 56. and 13-year-olds 207. And then there's a subset of those where an offence was proved. In the case of 10-year-olds, 0, 11-year-olds, 1, 12-year-olds, 15, and 13-year-olds, 88.
Attorney, why is it taking the nation more than 3 years after the initial commitment was made to make some basic law reforms that in the state of New South Wales, if you're only talking about raising the age to 12, would prevent such a small number of prosecutions? In New South Wales, we're talking about 19 prosecutions. I mean, why is this so hard to change the system to stop trying to jail 10 and 11-year-olds?
Well, you're correct that the number of prosecutions that raising the age to 12 would affect is very small. It would be one proven offence in the last 12 months and 18 prosecutions overall. At the moment, each jurisdiction is perhaps not including the ACT at 14 and maybe not Queensland at 10, but their position may have shifted. Trying to approach this at a harmonised level and fruitful discussions continue between Attorneys General.
But of course, the numbers of 10 and 11-year-olds that are ultimately successfully prosecuted doesn't include the number of 10 and 11-year-olds who find themselves potentially arrested by the police, taken to the police station, the subject of police surveillance. Are those matters you're looking at when you're considering the benefits of raising the age?
Well, it's not just a matter of, as you say, a matter of prosecutions. It's also a matter of what an alternative regime would look like. That if the age were to be raised, it's just not a matter of retreat, but again, perhaps comparable to our discussion on drug law, a matter of intervention and what appropriate service structure would be in place to deal with 10 and 11-year-olds who at the moment will go into the criminal justice system.
And have you reviewed what the ACT has done in that regard? Detailed forward planning, additional resources going into their equivalent of DCJ, in terms of diversionary, non-custodial resources to help the kids and ultimately make them, their families and society safer. Have you reviewed the ACT?
Well, that's certainly a model we're looking at. The Western Australian government had done a lot of work in preparing a paper for consideration by Attorneys General about, and again, this is why it's important to have a discussion at a national level to look at the different ideas that different jurisdictions can come up with what diversion would look like if the minimum age were raised.
Attorney, could I just ask some clarification about the numbers you gave? The initial numbers of 3 finalised convictions, I think it was for 10-year-olds, and 15 finalised convictions for 11-year-olds. Were they cases that went to trial or there was a plea and therefore there was a conviction?
Finalised court, my understanding, and Mr McKnight will correct me, finalised criminal court appearances would include a plea. They wouldn't just be trials.
Yes, so either
they don't include proven matters. So if the matter is a guilty plea, for example, if that's your question, that isn't included in those matters. They are all finalised matters. So they'll be finalised by plea, by a hearing, by some form of diversion, by any final court outcome.
where the charges have been proven?
No. So the 3 for 10-year-olds, there were no
3 10-year-olds?
Yeah, so there were no charges proven against 10-year-olds in that period, but there were 3 charges brought and finalised by the court.
So what happened in those cases? You have 3 10-year-olds taken to court,
I'd need to
potentially put in jail, taken away from their families. What happened?
So in that we haven't had a young person on in a detention centre who was 10 for some period, including on remand. I think what's likely to have happened, and I think I would need to take on notice the detail, is that the court used one of its diversionary outcomes, perhaps a caution or a conference.
And what about...
Or perhaps it just dismissed the charge.
Mr McKnight, what about the 15, 11-year-olds?
The same situation would apply. So if the charge wasn't proven, the court would have finalised that in some other way.
But none of them got a custodial sentence?
For 15... So there are some instances where 11-year-olds have been admitted into detention centres, typically on remand.
So were any of the 15, 11-year-olds who had their criminal matters finalised in the 12 months to September 21, were any of them, did the criminal justice system end up sentencing any to any kind of custodial sentence?
So I'm afraid that the data I have about custodial instances and the data I have about court appearances don't align in time period, so I can't trace those 15.
Well, then what if any evidence data do you have about custodial sentences for 10, 11, 12 and 13-year-olds?
It's probably easiest if we provide that data to you on notice. I can give you some numbers about...
If you have it there, Mr McBride, if you want to table the document...
No. Okay, so admissions to remand in the period 1 July 2020 to 30 June 2021, no 10-year-olds were admitted to detention centres on remand. 9 11-year-olds were admitted on those circumstances, 72 12-year-olds and 212 13-year-olds. In terms of... Yes, so, sorry, I misspoke. Those are all admissions. I have data on unique admissions as well. So this relates to the data by person. So
right.
that
they were instances of either remand or
not
custodial?
No, those were remand.
Those were
admissions
remand.
only.
Yes.
Yeah.
Do you have them for how many actual kids that happened to?
Yes, so the numbers are 0 for 10-year-olds, 11-year-olds is 6, 12-year-olds is 25, and 13-year-olds is 107.
107.
And I can... Just looking for my sentenced data.
Mr McKnight, if it's easier to just get the table prepared and then just table it with us sometime before lunchtime to provide
I'm sorry,
that.
I won't have time to do that.
Well, then I'm happy to wait.
Sorry, I don't have the sentencing data with me, do you? No. I don't have the sentencing data. I can provide that on notice.
Thanks. I think it's time.
All right, we're right on time, 11 o'clock. We'll have a morning tea break and then we'll come back in 15 minutes. Thank you.
Thank you.
Switch on again, please. We're on the air again. Opposition, questioning?
Thank you, Mr Chair. Mr Attorney, just turning to the modern slavery legislation. That legislation came into force and effect, was it in January this year? Is that
1
correct?
January.
1 January. And I think I understood Mr McKnight's evidence is that the recruitment for the substantive independent statutory officer is underway, and applications close at the end of March, and you hope to have someone in place by April or May.
Yeah, so to be precise, applications close on the 29th of March.
Yes?
The job ad is on LinkedIn, Seek, so if you've got good candidates, I would encourage you to... Absolutely.
Okay. And is the department doing the recruitment, or have you got an external consultant? Just from the ad, it looks like you're doing it.
I'm leading the recruitment
process,
yes.
I commend you for that. I mean, quite often with these sorts of things, there's these sort of recruitment consultants about whom I have no complaint, but it's good and refreshing to see agencies doing recruitment.
And I've already had a number of really high quality inquiries about the job.
Good. That's good. Mr Attorney, during the parliamentary debate on the most recent iteration of the legislation, your ministerial predecessor, having responsibility, made the commitment to revisit with the Commonwealth, when they're doing the review of their legislation this year, the $50 million versus the $100 million threshold.
Yeah.
Does that remain the government's position? Is that a commitment you'll maintain?
If he's made that commitment, I haven't changed or withdrawn that commitment.
The commitment was made on the 16th of November last year.
I think he sounded out the Commonwealth about reducing that threshold, but so far to no avail.
Yeah. Okay. So that commitment hasn't
remains,
changed.
yeah.
Okay. That's good to know. The thorny issue of bail. We discussed that last time in relation to the case of Mr. Ballack. I think on notice you answered some questions about that, and that was essentially a Commonwealth DPP matter, but it did highlight an issue potentially in the system about people volunteering to have privately provided ankle bracelets. On the 10th of November, I think, or thereabouts, you announced a high-level task force of police and others to scrutinise bail laws. Can you tell us who's on that group?
Sure. So just to clarify something you said, it was not a new task force. There already was a Bail Act monitoring group.
Okay.
That meets periodically.
Okay.
So I asked that existing group to look at these matters.
Mm-hmm.
It's chaired by a director of DCJ,
Mm-hmm.
and it includes representatives from DCJ, corrective services, the courts, tribunals and service delivery division of DCJ, the police force, the office of the DPP, legal aid, the Aboriginal Legal Service, Department of Premier and Cabinet, the Supreme Court, the Children's Court, the District Court and the local court. And it's been a forum that it was established in, I think, with the Bail Act around about 2015, and so it's been a forum that's subsisted since that time.
Okay, and so that's an existing body, and you've asked it to look at these issues that were canvassed in the
I
study?
referred about half a dozen cases to it,
Okay.
and asked it to consider what, if any, reforms to Bail Act might be required or appropriate.
And was the Ballack case one of those?
That was one of those.
That's
yeah.
one of those, okay. And are you able to, perhaps on notice, give us a list of the other cases that you've referred, so we can
I
have a
can
look
tell
at
you
issues?
now.
Okay, that's good.
Daniel Middlebrook,
Mm-hmm.
Salim Hamzi, Trent Jesk, Jeske, and Charbel Atti, Attie. There's one more, wasn't there?
Yes, there is.
And then I added two more to the list, Jason Williams and Ahmed, Ahmed Karim, Karim.
And are these all, which court do all of these emerge from?
One, I think, was the Supreme Court. They're mostly local court bail
Okay.
decisions.
And So you've referred these 6 cases. Have you set a time frame or requested a time frame?
No, I haven't. So I've received an interim report. I treat that report as cabinet in confidence. It's identified a number of issues, and I'm looking at the group developing recommendations on those issues.
Okay. Can you tell the committee, leaving aside what's in that cabinet and confidence paper, what are the issues that you saw emerging from those 6 cases you referred? I mean, obviously there's the issue of private companies providing ankle monitoring bracelets at the nomination of a defendant. That's one issue. Was that the major issue that emerged?
Well, that's the issue in the ballot case. The extent to which a court should rely upon the offering of a privately run electronic monitoring device as a mitigating factor to mitigate risk to grant bail. Whether there should be any change or addition to the show cause offences. So, as you know, the Bail Act that Attorney General Smith sponsored rewrote bail law so you would look at is a risk assessment. After some controversy in relation to that, there were amendments that identified a whole lot of serious offences as show cause offences.
Yep.
The most serious offences. So the question of whether there should be an expansion of those show cause offences, for example, whether the firearms offences that are covered sufficiently broad. So they're matters that are being looked at as well. Forfeiture of surety with when surety is put up to for bail, looking at the circumstances of that. So there are 3 areas that are being looked at.
Okay.
Among others.
Okay, apart from the review by that existing bail monitoring group, has there been any other further investigation done about whether self-arranged private surveillance measures are an appropriate risk mitigation strategy? Or are you just really going to rely on that advice that you get?
I don't know whether there has, but ultimately, I mean, there are a number of things you could do. You could, for example, legislate to create a presumption against relying on that, or you could, once bitten, twice shy. With the precedent that case is set, that I would expect judicial officers to be much more hesitant in relying upon electronic monitoring as a mitigating circumstance in future. So one approach is to rely upon judicial notice of what's happened and take that into account in future bail decisions.
Yeah, that's good. That could be a bit of a risky strategy. Is there going to be a review into the outsourcing of electronic monitoring to private companies more generally?
Probably not, because this is not something that the state organises or that
appreciate that.
It's something that accused proffer.
Yes.
So it's different from parole, where sex offenders are there's electronic monitoring of them as a condition of parole.
Yeah.
Or in some domestic violence cases, this is not a state-sponsored activity. This is something that's proffered, and on one view, the court can say, well, we're not satisfied as to the efficacy. I don't know that operationally the issue is with whether it is privately run or run by correctives. The issue is
standard?
That at the end of the day, an electronic monitoring device can be dismantled.
Apparently.
They're not foolproof. And it may be that with a sex offender who's not a flight risk, if the monitor comes off, then straight away, metaphorically and literally, alarm bells ring, and the offender, there's an attempt to abscond the offender in those circumstances. In a case here where there's a flight risk, I think whether it had been corrections doing it or privately run, the problem is he disappears and tries to escape the jurisdiction.
Indeed.
So I think it's more the risk associated with electronic monitoring per se than whether it's privately or publicly run. But as I say, there is that distinction between parole, for example, on the one hand, and something that an accused in a bail application proactively offers the court on the other hand.
Yes. Now, in answer, I think, to questions taken on notice or possibly supplementary questions from last time, you provided a search of all bail orders made in 2020 and 2021 using the keyword search as electronic monitoring or ankle monitoring as a condition of bail. And I think in 2020 there was 32 cases.
Sounds about right.
And in 2021 there were 47 cases, give or take. There were some limitations on the data. Are you able to say whether that electronic monitoring was all conducted by corrections, or is it? Would most of those be private? Is the BALAC issue quite widespread? I'm just don't.
Well, I think...
I assume so because you've referred it off to...
I'll take it on notice in case I need to correct my off-the-cuff answer.
Of course.
My off-the-cuff answer is I think they are all private. But the BALAC issue, it's the flight... So
the issue with bail is that whether they're a flight risk, whether they're going to attend.
that's the big issue. That's the big issue.
And he had significant means. I think that was the issue.
That's the big issue.
Yeah. But you've got some 70 or the better part of 100 cases over the last 2 years. We don't know how many have occurred this year. Your sense is that most of those would be private.
Probably all or substantially all.
Okay. So in which case, that's 100 people on bail subject to the electronic monitoring. Are there any minimum conditions that the electronic monitoring devices have to comply with? Pardon my ignorance, but is there an Australian standard that these have to meet?
I don't know the answer.
Or can you go to get them at Aldi and there's a risk that they can just be jimmied? I mean, this is a serious question.
Yeah. Look, I don't know the answer.
I'd
be surmising that there would be... there may not be an Australian standard, but I would surmise that when a judicial officer is asked to grant bail, subject to an electronic monitoring condition, that the officer is told what the technical specifications of the monitoring are.
I think so.
At the risk of contradicting you, I'm making the reverse supposition that maybe judicial officers are assuming that this is actually handled by the government. That's, for what it's worth, that's kind of the feedback I've had. Could I ask you to take this on notice and give us an answer about is there an accepted standard that devices have to meet? Is this something the judiciary are aware of? We'll take it. We'll take that as far as we can.
But I'll take that on notice. But as I said, it's different from parole, where correctives are saying we are going to impose electronic monitoring on a parolee as part of the state attempting to protect the public.
Of course.
Here, the state is not asking for anything. The police are not asking for it. In fact, typically they would oppose bail, notwithstanding electronic monitoring. This is the accused proffering electronic monitoring, saying, hey, I'm not at risk because you can stick a bracelet on my ankle.
Yes, but of course the degree to the comfort that the community can take from that might depend on the quality of the devices, the ease with which they can be dismantled. I assume that some would be, high security. If you try and dismantle them, something nasty might happen. Others might just fall off like a cheap toy. I don't know.
Yeah, I think they're more than cheap toys, but none of them are foolproof.
No.
And I suspect that a determined wearer of such a device can sooner or later dismantle them.
Okay, so just to be clear, we want to know whether there's a standard that they have to meet and who's responsible for that, and the degree to which the system is aware of all of those limitations.
Sure.
Going back to those 70 or 80 odd cases, I think, and certainly wasn't the case of the BALAC matter, the police generally oppose these, or the prosecution opposes them. Can you tell me, of those cases in 2020, 21, and indeed any that have occurred this year, how many that the authorities appealed against if they opposed them?
I'd have to take that on notice.
No, please. I'm assuming police can challenge bail decisions where they're not successful, can't they?
In theory.
Yeah. Can you tell us again on notice how many of those bail decisions are in fact appealed by the police or the prosecution?
Certainly. Sorry, those meaning the ones where there was an order for electronic monitoring?
Yes, in the first instance, but secondly, in relation to bail decisions.
Generally.
Yeah, I'm just kind of interested in that phenomenon.
And just to be clear, an appeal against whether or not bail is granted as distinct from bail conditions.
Yes. bail is granted, and thank you for reminding me, Attorney, perhaps also on the issue of bail conditions, I think that would be very useful as well. Sorry to give Mr Tidwell and others more homework, but I think that would give us a fuller picture of the...
Can I clarify
Sure, Mr. McDonough.
something about the Bail Act? Because what the Bail Act provides for is for prosecuting authorities, the police in particular, to make a subsequent detention application if they feel that the bail decision was incorrect. So they can make that either in the same court, or they can go to the Supreme Court to make that. So it's not technically an appeal as such. It's a further application to detain the person who has got bail.
Sure.
Is it de novo?
Yeah.
Exactly.
Yeah, well, there are different types. I mean, there are different terminologies applied to these. There are different types of appeals. I guess what I'm interested in is any applications made by the police or the prosecution challenging grant of bail or challenging bail conditions, if we can use the word challenging in that sort of encompassing term. So you've got the interim report from the bail monitoring group. Is the ball sort of now in your court, or are you waiting for their final report, or are you going to give them some feedback about your initial views?
The ball is in my court.
Okay. And do you have a time frame which you may move the ball back into somebody else's court?
I don't have a precise time frame, but I know it's a matter of public interest, and I'm keen to be as prompt as possible.
Yes, okay. So what's the process from here? It's an interim report. Do you expect a final report to basically confirm it?
Well, I say confirm it. I mean, they without waiving cabinet and confidence protection.
Well, you can't waive that privilege, Mr. Chairman.
It identifies issues rather than makes recommendations. So,
Okay.
So I need to go back to them to identify the precise areas I'd like them to investigate further and come up with recommendations.
Okay. So it's kind of a broad brush. These are the issues. You go back and say, please colour these in.
Yep.
And then they'll come back with, at least you assume they'll come back with a set of definitive recommendations, which you will then consider, adopt, modify, whatever.
Well, I don't know how definitive they'll be, but I would anticipate a set of recommendations.
Okay. You've given an indication of the organisations that are represented on the bail monitoring group. Given some of the experiences I've had with interdepartmental working groups, they have often a shifting membership depending on who's unlucky enough to be in the office when these are scheduled. And so some of the focus can be blunted by shifting membership. Is there a fixed membership for this particular review, or is it going to be subject to the same kind of, kind of put it neutrally, interdepartmental vagaries?
Just before Mr McKnight answers that, I might say, having received the report, I am looking at supplementing the membership of the committee, of the group.
Supplementing it in what way?
Well, I'm yet to determine that.
Okay. What considerations or issues gave rise to that inclination?
I want to make sure that its recommendations are robust and driven by empirical evidence.
So we're talking about someone else from Boxar?
That's a possibility.
Are we talking about someone with particular legal expertise who could advise about the practicality or the workability of a particular solution?
All those are possibilities.
Okay. All right. And I understand the ball's in your court, but I assume it'll be a matter of days or weeks before you go back to them, given the public interest in this matter, given the ballot controversy, given that there's now obviously a range of cases, like some 80 cases, if not 100 cases now in the system that might be, have the same vulnerability. I assume this is a matter you wouldn't want to let drift.
Correct.
Okay. Can you give us a more definitive time frame?
No, I can't. But I'd certainly want to be landing a final position in the next couple of months.
Okay. And
Couple of months.
a final position as to this initial advice, or a final position as to a definitive course of action, at least in your own mind.
A definitive course of action. So that's that is not a promise or a warranty or but that.
You're not giving an undertaking to the court.
It's not an undertaking to the court or to anyone else, but that's the aim.
Could I put these words in your mouth then? Is it your present inclination that you would be working diligently to have legislation to address any of these issues this year? Would that be a fair assessment?
Yes. If the unthinkable were to happen and we lost government, I'd want to have resolved it from a legislative viewpoint this year.
I think that is my time for now.
Yes. Attorney, through you to Mr. Tidball. Mr. Tidball, you would be aware of the obligation on the heads of agencies to complete a written declaration about any actual or potential conflicts of interests under the Code of Ethics and Conduct for New South Wales Government Sector Employees.
Yes, I am.
And as the Secretary, my assumption is you've completed such a declaration.
I have indeed, Mr. Shoebridge.
And I'm assuming compliant with the code, you did it in writing?
Yes, I did.
And then who then did you provide that declaration to?
The Department of Premier and Cabinet.
Yes. And that's an unambiguous obligation under the code on your part, isn't it?
Yes, it is.
And, Attorney, if Mr. Tidball came to you and tried to give a verbal disclosure of his conflicts or potential conflicts of interest in lieu of a written disclosure, you would know that would be unacceptable, wouldn't you?
Well, I'd expect Mr. Tidball to comply with his legal obligations, which would be to make a disclosure in writing.
Yeah, and that's unambiguously the case, and it has been since at least 2015, isn't it?
That's my understanding.
Yep. Mr. Tidball, do you know, and I'm in no way suggesting you've done anything improper here, Mr. Tidball. I'm just testing the process. Yeah. Mr. Tidball, do you know what, if any, penalty there is on an agency head for failure to disclose in writing conflicts and potential conflicts of interest under the code?
I imagine that it would go to the core of the agency head's contract of employment.
Attorney, it would be a serious matter, wouldn't it, if an agency head or a secretary in the DCJ cluster failed repeatedly to provide a written declaration of interest as legally required under the Code of Ethics and Conduct. That'd be a very serious matter, wouldn't it?
Well, it depends upon what the non-disclosure was. Any non-disclosure shouldn't occur, but if it were a trivial non-disclosure, then it may not be a serious matter. It may still be a breach of the code, but it shouldn't occur.
The failure under the code to at least annually provide the written declaration of actual and potential or perceived conflicts of interest. That, as you made clear, that legal obligation to provide the written declaration consistent with the code, that's a serious matter, isn't it, Attorney?
Well, it's a weighty matter, but I don't know whether you're leading to some particular example. So I don't want to comment in the abstract without knowing what the example is. But all public servants and ministers should comply with their legal obligations so far as disclosure is concerned.
Well, Mr. Tidball indicated, I think quite properly, that the failure to do something so fundamental from a senior executive to provide at least annually the written declaration of actual potential and perceived conflicts of interest under the code would go potentially to the employment contract. A very serious matter.
Well, it's something that shouldn't occur, but how serious it is would depend upon, among other things, what ought to have been disclosed and what was not disclosed.
Tony, you're not suggesting that those core transparency requirements, which are not just there to identify an actual conflict of interest, but are there to provide assurance to the public and the public sector that the right thing is being done and that disclosures are being made. You're not suggesting that the failure to do that is only tested against whether or not there actually was a conflict of interest, are you? You're not seriously suggesting that?
No, what I'm saying is all ministers and public servants should comply with their legal obligations, including those of disclosure. The failure to provide any return or disclosure form is a breach that should not occur. The gravity of that failure would be measured, among other things, against what should have been disclosed and was not.
Well, the head of an agency has a particular obligation to lead by example on matters such as integrity, and it's a core integrity issue, isn't it? To disclose actual, potential or perceived conflicts of interest. The agency head should be leading by example, shouldn't they?
Ministers and agency heads should lead by example. Disclosure is part of an integrity process within government. The gravity of non-compliance will depend upon, among other things, what should have been disclosed and was not.
Well, just yesterday, the Law Enforcement Conduct Commission handed down its findings about former Police Commissioner Fuller and found that in 2017, 2018, 2019 and 2020, former Police Commissioner Fuller failed in his legal obligations to provide a written declaration of actual, perceived or potential conflicts of interest for an entire 4 years. That's an extremely serious matter, isn't it?
Well, I haven't seen the report, and I'd have to read the report to understand what the implications were of that non-disclosure and what ought to have been disclosed but was not.
Well, it's not a question of what ought to have been disclosed. There's a standard form prescribed under the code, which it is mandatory to complete and to sign a declaration under that it was complete. This isn't a hypothetical question. There's a standard considered form that is required to be completed at least annually. You know that, don't you?
Yes. Well, but what you are trying to ask me to do is not identify whether or not there is a breach that should not occur, but opine that it is extremely serious or very serious, where I'd have to look at the report, the LEC report, and understand the gravity of what it was that ought to have been disclosed and was not.
No, Attorney, this isn't about what should or shouldn't have been disclosed. That's a secondary matter. The fundamental obligation for an agency head to comply with their obligations under the code, as you made clear, legal obligations under the code, to disclose actual, perceived or potential conflicts of interest, that of itself is an essential integrity matter, and the failure to do it is a serious matter. Or do you as Attorney General not treat it as a serious matter?
Well, I've just said no breach of mandatory obligations should occur. Its seriousness will depend upon the gravity or the implication of what it was that ought to have been disclosed and was not disclosed. That doesn't mean that it wasn't a breach that should not have occurred, but whether it is a very serious breach or a serious breach or a somewhat serious breach will depend upon what it was that ought to have been disclosed and was not.
Attorney, the Law Enforcement Conduct Commission ceases to excuse Mr Fuller for that failure to comply because he had a chat with the former police minister and verbally disclosed that he had some horse racing interests. That a verbal disclosure does not come close to complying with the requirements under the code, does it?
That's my understanding.
Can you understand how, given that uncontradicted evidence of 4 years of failure to disclose in accordance with the Code of Conduct, in writing, actual, perceived or potential conflicts of interest, can you comprehend how the Law Enforcement Conduct Commission could have come to the conclusion that there were no adverse findings to be made against Mr Fuller?
Well, I don't think I can fairly answer that question without having read the report. I've said a number of times now that no no failure to comply with mandatory obligations, it's somewhat circular, but no failure to comply with mandatory obligations should occur. The seriousness of any failure depends upon the gravity and the gravitas of what it was that should have been disclosed and was not.
What, if any, role does DCJ have over ensuring that these basic integrity matters are adhered to by the heads of agencies, including the Police Commissioner?
I'll let Mr Tidball answer that.
I'm unaware, Mr Shoebridge, that...
You have to speak in the microphone.
Sorry, Mr Shoebridge, and I note that Ms Boyd is here from the Department of Premier and Cabinet, but my understanding is that in respect of those contracts that DPC does not have a responsibility.
All right. Ms Boyd,
Yes.
DPC was meant to be... Sorry, I'll start again. Ms Boyd, the Department of Premier and Cabinet failed to get a written declaration of the actual perceived or potential conflicts of interest consistent with the code from the Police Commissioner in 2017, in 2018, in 2019 and in 2020. What did DPC do in relation to that ongoing legal failure by the Police Commissioner?
DPC's role, or the Secretary of DPC's role is to accept the declarations from agency heads, being heads of departments and other agencies that are prescribed in Schedule 1 of the Government Sector Finance Act, and that is done. Statutory officers are somewhat different under that Public Service Commission's direction. Whether they should be or not is a question for the Public Service Commission, but the legal position is slightly different, I think, in respect of agency heads compared to statutory officers like the Commissioner.
The Public Service Commission gave a direction in 2015, at least according to the LEC, that all agency heads, including the Police Commissioner, had to provide such a declaration consistent with the Code of Conduct. You know that, don't you, Ms Boyd?
I think there might be some uncertainty as to whether or not that direction applies to department heads and agency heads versus statutory officers like the Commissioner of Police. But I think these questions are probably better directed to the Public Service Commission because it is the Public Service Commissioner's direction.
So, Ms Boyd, you failed to get a declaration from the Police Commissioner, when I say you, DPC, for 4 years running, and there's not even a system in place to send a polite follow-up or to check about the absence of critical documentation like that. And the position now is, there may be some legal ambiguity about it. Is that the situation we're in?
No, I wouldn't put it that way. There is a system in place for DPC to write to, of course, agency heads and statutory officers do provide those declarations voluntarily. I'd have to take that on notice and check what letters were provided to the Commissioner in this instance. But no, it is incorrect to say there is not a process in place for that.
So, did DPC chase up the Police Commissioner for the 4 years of non-compliance?
I would have to check the records on that, Mr Shoebridge.
Will you provide on notice any correspondence? Indeed, as my colleague Mr Searle suggests, will you provide, if at all possible today, first of all, an answer, which should be extremely achievable, but secondly, if possible, any actual correspondence that came from DPC to the police?
Yeah, I'll take that question on notice and get back to you as soon as we can today.
You see, Attorney, integrity has been an ongoing issue with the New South Wales government and at different times the New South Wales police for decades and decades. And here we have an, I would have thought, unambiguous integrity breach, and yet nothing has happened. Indeed, the Law Enforcement Conduct Commission's report reads like it's the PR report for former Commissioner Fuller and gives him glowing commendations. How does this happen?
Well, Mr Shoebridge, if you are impugning the integrity of the Law Enforcement Conduct Commission, then I just...
I'm impugning this report, which reads like a PR report for the Police Commissioner, and it's not even signed or authored. We don't know who authored it from the Law Enforcement Conduct Commission.
Well, Mr Shubridge, you have asked me repeatedly about the seriousness of any non-compliance with mandatory disclosure obligations. And I haven't seen this report until now, and I still haven't seen it, but Mr McKnight provides me with an extract of the report's findings, and it found that there is clearly no substance in any of the allegations that have been made against Mr Fuller. At the end of the day, Mr Fuller has served 34 years of loyal service with the New South Wales Police Force and has been responsible for significant reforms, etc., etc. The evidence does not support a finding of serious misconduct or any misconduct at all. So I don't know how LEC arrived at those conclusions because I haven't seen or read the report, but at least it would suggest that our independent oversight body has considered that whatever non-compliance there was with by Mr Fuller of his disclosure obligations, that does not amount to a finding of serious misconduct or any misconduct at all.
How can the repeated failure to comply with the Code of Conduct and the serious legal obligation under the Code of Conduct to complete written declaration of interest, how could that not be misconduct or lead to a negative finding against the head of the person responsible for New South Wales Police?
Well, I'm at a disadvantage compared with you because I haven't seen the LEC report or read it. If the question is, if there is a mandatory disclosure obligation, is it a breach not to comply? Well, by obviously sort of circular reasoning by nature of being mandatory, yes, if that occurred, that is a non-compliance. Does it rise to the level of serious misconduct or any misconduct at all? Well, apparently not in the opinion of our independent oversight body.
The Law Enforcement Conduct Commission suggested that the complaints against Mr Fuller were malevolent attempts to cause him harm and critiqued the ABC investigation, at least implicitly. Are you aware of the fact that the Law Enforcement Conduct Commission never contacted the ABC about these matters?
I don't have operational oversight of how the independent oversight body, the Law Enforcement Conduct Commission, conducts its inquiries. There is an inspector, and if the ABC or others are dissatisfied with the reasoning process or the consultation process or the lack of signatures on a report and so on, they're all matters that can be taken up with the inspector.
Surely, Attorney, you can find out, as one of the ministers responsible for the LEC, at least who authored the report. It is an extraordinary proposition that the Law Enforcement Conduct Commission would deliver a report with such haste within a month of the allegations airing and not even indicate who authored the report. Surely you can find that.
Well, if you want to ask me on notice who authored the report, you can ask me that on notice, and I'll get advice.
Attorney, are you aware of a KPMG review of Marrickville Legal Centre that was initiated by Legal Aid?
Not specifically. I'm aware of issues surrounding Marrickville Legal Centre, and there are potential governance issues concerning that and an aborted program in which it was participating.
Well,
I'm not aware of a KPMG report.
Well, Marrickville Legal Centre was, on my understanding, trying to expand its services and do a joint project to provide migrant legal service. Something I would have thought you would endorse, Attorney.
Yeah. So my understanding is when we announced increased funding for community legal centres several years ago, we invited applications for new projects, and one of the successful bidders was a joint venture between Marrickville, I think the Inner City Legal Service, Redfern and Kingsford, for a four-way joint venture for providing free legal services in that migrant employment space. I'll invite Ms Hitter to supplement in a moment, but my understanding was Legal Aid found, and I think Marrickville were going to take the lead role in that joint venture. There were governance and other issues surrounding Marrickville that led to termination of Marrickville, but the project continues with the other three community legal. It may have been rebadged and renamed, but in substance the project continues with the other three legal centres running it. And there's, in substance, been no disruption to client services. But would you like to supplement?
Yes, thank you. That's correct. The service itself is continuing to be run by the three other legal centres for the third and final year of the funding. Marrickville Legal Centre's involvement ended on the 1st of July 2021.
That was a decision of Legal Aid, Ms Hitter?
It was a decision that was made in the context of a number of considerations, and yes, it was communicated to Marrickville Legal Centre that the funding would be discontinued to them on the 1st of July 2021.
We'll come back to this.
Thank you. Mr Attorney, in relation to the coronial inquests into the deaths of John, Jack and Jennifer Edwards, the coroner made a number of recommendations that the government of New South Wales should do various things. Now, most of those were directed to the police, but one of them, recommendation 6, was, and I quote, that the New South Wales Government take steps to update the list of prescribed offences in Clause 5 of the Firearms Regulation 2017 to include any personal violence offences or domestic violence offences defined in the Crimes, Domestic and Personal Violence Act 2007. Now, I appreciate that you're no longer the Minister with carriage of that legislation, but as Attorney General responsible for the Coroner's Court, are you aware of where the New South Wales Government is up to in terms of responding to this coronial recommendations?
So I've never had portfolio responsibility for firearms legislation.
No, but the DV Act you did at one stage. I think at the last estimates you did. You no longer do.
Well, I did for the crimes. Well, no, I think I've still got crimes, domestic and personal violence.
Okay, well,
I've still got
better.
that. I've still got that.
Okay, good. I couldn't see it on the list in the allocation of acts, but anyway, I'm happy to.
I've still got that.
Okay, in which case, where are you up to with recommendation 6 then, Mr Attorney?
So that sits with the Police Minister. It's not incorporating into what I'll call my legislation.
Okay.
Something from firearms. It's the reverse. It's the firearms regulation incorporating definitions from criminal legislation for which I have responsibility.
Now, this might be because the way in which the coroner framed the recommendation, a lot of the recommendations are directed to the police force, but this one's directed to the New South Wales Government.
Well, because it's a regulation.
Sure. And, but can you tell us, do you have any visibility or any understanding of where implementation of this recommendation?
It's supported. I'll have to get back to you on the precise time.
Yeah, I think
it's certainly supported.
I think even the police service generally supports this, and I think I don't think there's any opposition. And it's a reg, so a reg could be changed fairly easily. So you'll take that on notice?
I'll take that on notice.
Okay.
Thank you.
Thank you for that. In relation to the Kathleen Folbigg matter, I can feel you wincing, Mr Attorney.
No, not at all.
Now, you'd be aware that on the 3rd of March there was a petition sent to the Governor and to you requesting a pardon on the basis of certain new material. Now, my understanding is that there was certain scientific evidence raised at the 2019 inquiry by Commissioner Blanche showing that the two girls, Sarah and Laura, had a certain genetic mutation which might have impacted on their death. But the actual scientific study, the detailed study, wasn't available to Commissioner Blanche when he did that report. That study was published in November 2000, and it seems to, as you know, on my understanding, suggest that there might have been a genetic mutation explanation for at least 2 of the deaths. I understand some more work is being done in relation to the other two children. The Australian Academy of Science has released a letter it sent to you about that evidence, and I think they've offered to brief you. Is that correct?
They have.
Is that an offer you will take up to inform your evaluation of these matters?
No. So look, I'm approaching this as carefully and as thoroughly and as promptly as possible. I have been criticised for sitting on the petition for 12 months. In my view, that criticism is unfair. We have had the petition for a year, and some grounds are set out in that petition. But from time to time, the petitioner has added to the material that she would like us to consider. So I have been waiting effectively for the case to close rather than drip feeding senior and junior counsel. Now, I suspect that the principal material on which they rely was supplied with the submission, but they have not, they have delays in closing their case and providing more material. Now, there's been some dispute in the media about how many pages have they supplied and how many, is it us wanting more? The petition, I think, had about 700 pages. They have either provided or by cross-reference referred to about another 1,200 pages. I'm told that Crown solicitors who are acting for me in this consider that senior and junior counsel who've been briefed need to look at another 2,000 or 3,000 pages to get the context. Primarily all that's gone before. I'm conscious that if there were to be a successful petition, I'm not saying one way or the other whether it's successful, but that the utility of that success diminishes day by day if someone is sitting in prison waiting for that. So I'm conscious that it needs to be resolved as expeditiously as possible. But until a few months ago, the petitioner had not closed her case. Senior and junior counsel have now been briefed in the matter, and I would anticipate being able to say something within a month. In terms of the offer from the Academy of Science, having taken advice, the view I took was I shouldn't be receiving submissions and having private meetings with third parties. It's a matter for the petitioner to identify what she wants to rely upon. She has identified that, I think to some large extent, she does want to rely upon the material and arguments of the Academy of Science, and to the extent that she's indicated as the case, that will be taken into account in reaching a decision. But having taken advice, it's not appropriate for me to be having private hearings with people for or against the petition. It's done on the papers. This is a process that comes after a trial, after 2 appeals to the Court of Criminal Appeal, a special leave application to the High Court, a judicial inquiry. So there has been a lot. This has gone through many judicial hoops. But that said, the fact that has occurred in the past doesn't mean that what is said to be now new material won't be looked at thoroughly and fairly to arrive at a decision.
Okay. When was senior and junior counsel engaged?
So initially, initially we had engaged Hamid Danji, who then took a Supreme Court appointment.
Well, I think that's probably your fault.
It's your fault.
That's my fault.
It's your fault.
But I think senior and junior counsel, I'll take this on notice in case I've got to correct or adjust the answer, but broadly speaking, they may have been retained earlier than when I say Ms Folbigg closed her case, but they've only been actively looking at it probably about 3 months ago.
Okay, and I take what you say about you felt it wasn't appropriate, or you were advised it wasn't appropriate to meet with third parties who might be advocates. But as I had understood the Academy of Science, although what they were seeking to do was that identifying you as the decision maker, they were just wanting to make sure that you had the scientific information about the genetic mutations.
Well,
is that something that maybe senior and junior counsel might be a part of?
Yeah, so to the extent that the Academy of Science has put everything in writing, senior and junior counsel will be looking at that, and Crown solicitors to advise me. And if if there is to put it in legal language, they think that I need further and better particulars on something, then I expect they'd advise me on that.
Okay.
But at the moment, I don't anticipate that is the case. I anticipate that we have everything we need to form a view.
Okay. So you will form a view, and then what's the process? You make a recommendation. Is it to the governor? Or
I make a recommendation to the governor. And look, I'll be very clear on this. It's not a tick and flick.
No, I appreciate that.
It's an exercise of an executive role, not a judicial role.
Yes.
But it's not a. It's there are very grave consequences that I take very seriously.
I understand. I might have had some involvement in a similar process so many years ago. Mr. Attorney, I guess an alternative to the governor exercising certain functions would be to direct the conduct of a coronial in relation to the deaths of the children. I understand coronials weren't occurred. Is that sort of like a possible secondary process you might consider in this matter?
So I, as Attorney General, have a power to direct an inquest.
You do?
I don't think the power has ever been exercised. I don't think that is part of the application here. There are other procedural possibilities. The applicant could have made an application to the court directly for an inquiry to the Supreme Court. So there are two avenues. They could go to the governor, or me via the governor via me, or they can go to the Supreme Court. They've elected to come to the governor, and I'll get advice, or I'm getting advice as to whether or not there should be any remedy or relief, and if so, what form that would best take.
And what is the application to you? Is it for the royal prerogative of mercy, or is it a pardon?
It's an application for a pardon, which is effectively the royal prerogative of mercy.
Yeah. Right.
And it's only very clear, under our constitutional system, it's technically the governor's determination, but the governor would act upon the advice of the Executive Council and yourself.
That's correct. So I think, among other things, the governor can probe and ask questions, and but at the end of the day,
Governor will act on
the governor acts on the advice of Executive Council.
Yeah, and it's your role to take a recommendation to Executive Council, and that's how it'll work. Is that right?
That's correct.
Yep. It doesn't have to go through Cabinet first. It's the exercise of your legal functions.
Look, it may or may not go through Cabinet.
Okay, understood. I won't press you further on that. Mr. Mosselman?
Yeah, Attorney, I've just got to...
But I just get to stress, at the end of the day, it's not a political decision.
No, I understand.
Although I'm wearing it's an executive decision, not a judicial decision.
Well, I think I refer to it as a exercise of your legal powers as Attorney General.
Attorney, I think anyone hearing that exchange between you and Mr. Saul would recognise the seriousness with which you take the matter.
There's no criticism of that.
Attorney, a couple of questions on the Walama court. The original proposal was to have it as a legislated standalone court. Is that still the case?
No. So the district court is embarking on a list, a Walama list, that doesn't require any legislative underpinning. It's effectively a practice note.
Yeah. So that means it can be easily abandoned if the decision was to abandon it, basically. It can be easily abandoned as a practice note.
Oh, well, it could, but at the end of the day, it would be a decision of the court to do that, not an executive decision. But I think people are very keen to embark on this. It's got a lot of support, and it's a pilot that's going to run for a number of years.
You've supported it pretty heavily in the media.
Well, I think it's something. It's something that we've got to try. We all know the dreadful statistics about Aboriginal overrepresentation. We have to look at ways to achieve those closing the gap targets. We've got a target of reducing adult Aboriginal incarceration by 15% by 2031. That is going to be a very, very challenging target. And measures like this, if you don't try them and see whether they work, you will never know. And the other important aspect of it, it's not just about reducing offending and reducing incarceration. It's also about having Aboriginal communities having confidence in fair treatment and in the justice system.
Yeah, Mr Attorney, I appreciate you said there's a lot of support for the proposition, and there certainly is. When I chaired that First Nations Deaths in Custody inquiry that recommended support for this, I think all of the legal fraternities and a lot of stakeholders certainly supported the establishment of the Walama Court, but they rather had in mind a sort of supported by legislation to make it more robust. Is there a particular reason why why we've gone down this practice note and a special list?
This will be robust. It will be evaluated by Boxar to see whether if people go down the Walama stream, they are more or less likely to reoffend. I'd anticipate there'd be qualitative evaluations as well about how what I'll loosely call users of the system, the accused, lawyers, judicial officers, victims, social workers, and so on, how they feel it's going. But this will be a robust pilot. If we are to pour more money into this, if I or whoever, in 5 attorneys general time, however many we have to go to Cabinet and say, or ERC and say, I want money for this, there's going to have to be an empirical underpinning. So I'm determined to make sure that it's a robust pilot that gathers that empirical underpinning.
So we had this discussion last time about currently there's that lack of empirical, but we agreed, I think, last time that if you don't try something new, you'll just get the same old outcomes. Yeah,
so others might dispute. I don't think there's any direct empirical underpinning for this at the moment. There is what I call circumstantial underpinning. The drug court works. Circle sentencing in the local court works. There's Boxar evidence there that they reduce reoffending. So borrowing concepts from there gives you cause for optimism that this will work as well. But unless we try it, we'll never know. And of course, it's not just a matter of do you or don't you. It's also how, and if it needs, recalibration in some way down the line to make it more effective.
Is the reason you've embarked on this pilot process simply because there was hostility within the more conservative elements of the government to an innovation of this kind, and this was something you could do without that kind of approval?
I think to be fair, where it is untried, and I know Victoria has something similar, but my understanding, and I'm happy to be corrected, is that there might be some anecdotal evidence supporting it, but there's no direct evidence here. If you don't want to set in concrete something that may or may not work. We're doing this because we're optimistic that it will work. I want Boxar to analyse it so that there's an evidentiary base to expand it and make it permanent. But the Youth Koori Court, that's a pilot as well, and we've expanded that to Surrey Hills from Parramatta, and I'm certainly keen to see more of that. So no, it's not a matter of appeasing conservative elements. It's more a matter of making sure that if we are going to expand something in the future, it works.
I think I was more suggesting that you were being blocked by conservative elements from doing something a bit more adventurous, but this reflects your own more cautious, gradualist outlook.
Well, it's an evidence-driven outlook. We have to reduce Indigenous overrepresentation in the criminal justice system. We have to try things, but if contrary to my optimism, this doesn't work, then we have to be prepared to pivot and put money into things that do work, which might mean to pivot more into circle sentencing or more drug courts or Koori courts or justice reinvestment. We want to make sure that we are reducing Aboriginal overrepresentation, but in fairness to the taxpayer and in fairness to Aboriginal communities, we have to make sure that every dollar we spend is having that result. We're spending in the best way possible, which is why it's a pilot and why Boxar will evaluate it.
So are there KPIs, Attorney, against which the government will assess?
Not really. I mean, one of the aims is to reduce reoffending, but as I said before, that's not the be-all and end-all. I want to promote Aboriginal confidence in the justice system, and that's part of it as well.
Is there a time frame for reassessment of?
That'll take several years because you've got to do a longitudinal study of offenders. So, if you want to work out are they reoffending, you're going to have to do it over a period which allows a year, 2 years to see whether people who are convicted of offences have reoffended, and you've also got to do it over a sufficiently large cohort so that the results are statistically robust.
Well, it certainly seems the hope of the National Indigenous Times that the pilot is if the pilot is successful, after a number of years, it is hoped that it will develop into a permanent Walama court.
Well, that's my hope. But when I go to ERC or whoever's Attorney General down the future goes to ERC and they want money for this, chances are with competing priorities, they'll need to demonstrate it works. And when I say competing priorities, I'm not talking about versus spending money on roads or trains or schools or hospitals, but competing priorities within the diversion space. Is this the best way to spend money? I'm optimistic that it's going to be a good way, but that optimism needs to be backed up with data.
All right. In relation to that, so how many years will the longitudinal study take?
I haven't got precise advice from Boxar, but I think it's going to take certainly a number of years.
Are you able to provide us on notice with the Boxar framework so we just know
Sure.
what they're working with?
Certainly.
You mentioned the Youth Curry Court. Where's that pilot up to? I know it's been extended from Parramatta to Surrey Hills. What's the latest?
Well, there's still I think it's being evaluated. There's an evaluation due in April, I think.
That's correct.
Yeah, there's an evaluation due in April, an outcomes and cost-benefit evaluation, which is expected next month.
Okay. Just changing gear a little bit to the issue of strip searches. There's been I think a couple of LEC recommendations on that, and also I think the Special Commission of Inquiry on ICE also made some recommendations. The recommendations are that the law enforcement powers and responsibility legislation be amended to provide more specificity in its definitions of strip searches and guidance as to when they can and can't be used. Now, I think you're still the minister responsible for LEPRA.
So, yeah, I think I have joint responsibility.
You do with the police minister?
Yep.
So the police force, I think, supports the thrust of those recommendations, I think. Why is it taking so long to get some action on this? Can you tell us, given the body of work that's already been done and the problems that have been clearly highlighted, particularly in the LEPRA, in the LEC 2 reports, what time frame for action could we expect?
Look, I can't give you a time frame. I'd hope to have the matter resolved this year.
Mm-hmm. Again, before the election, just in case. Just in case
before the election. Look, there were numerous recommendations in that report. I think only three were directed to the government. On one view, those recommendations were about clarity rather than adding to or subtracting from strip search powers.
Well,
and,
it was quite clear from the reports that the police either misunderstood or that strip searches that shouldn't occur were occurring, or they weren't occurring with in the safe way that they should have been.
I think police will say that they have done a lot of work in operational matters to address some of the concerns in that report, but I accept that there are at least the three recommendations directed to the government are still outstanding.
Yeah. So this was more than 2 years ago. Can you tell us what the hold-up has been? Is it the institutional resistance to change? Is it disputes between ministers, or is it just simply the back of the queue?
No, it's certainly not the back of the queue. I mean, it's an important matter, and on the one hand, you want police to have appropriate powers to investigate potential crimes. On the other hand,
you want those powers to be exercised lawfully.
Exercised lawfully, and also, in ways that as I've said before, I've never been strip searched, I've never seen a strip search, but I can imagine it's potentially very traumatic for the subject of that search, and we make sure it's used appropriately and not overused, but also that police have clarity about what their powers are.
Say about the bill.
Well, Attorney, the report made it clear that police didn't know what their powers are. And in fact, police officer after police officer after police officer gave evidence to the Law Enforcement Conduct Commission that they had no idea what was and what wasn't a strip search, and what the laws were that permitted them to undertake a strip search. That's a very fair summary of the LEC report.
I don't know it's a summary of the entire report, but certainly that is a theme that emerged from the LEC report.
And that's now years ago, and we still have very imperfect, very unclear laws about strip searches. Well, when are we going to get it fixed?
Well, as I said, I've got joint responsibility for this act. It's not just my prerogative to bring something to Cabinet. It's a joint responsibility of the Police Minister and me, and I would hope that we'll resolve the matter this year.
Attorney, you recall receiving representations from the Bowerville families, the families
Yes.
of 3 children murdered in Bowerville.
Yes.
Yep. Can you remind the committee when those representations were received?
I've received various representations.
And the most recent representations?
I don't recall, but I think you're leading to, and I would accept it was some time ago.
Mr McKnight may be able to assist.
I'm sorry, I don't know.
Attorney, it was a very significant amount of time ago. There was an initial response drafted by your department, which I think you accepted at the time went in error. Is that right?
That's correct.
And then that was withdrawn.
That was about a year ago, I think.
Indeed. And the families are still waiting? Given how much they've been through, how do you explain yet another year of delay to the families, this time in just getting a substantive response to their correspondence to you?
Look, what they've been through over 30 years is heartbreaking, and I acknowledge your robust advocacy on their behalf over many years. I can only apologise that we haven't had a response by now. To be honest with you, I don't expect a response within weeks. It is something. It's not just me as the Attorney General deciding to respond. There are implications for other parts of government. Unfortunately, a whole of government response has taken a very long time.
Well, the former police commissioner, Scipione, who I had many disagreements with, but I acknowledge his work in going up and apologising on behalf of the New South Wales Police for the appallingly inappropriate way the police investigation was initially handled. But that took years and years. How long is a reasonable amount of time for the families to wait for a response to their most recent request for, if not ultimate justice in court, a measure of justice through the executive functions of the government? What's a reasonable time to wait?
I can't put some sort of precise time on that. They have been very patient in very extraordinary circumstances, and I'm grateful for that patience, and I'm trying to get it resolved as quickly as I can.
Well, can you give an indication of what is causing the delay?
No, I can't do that in terms, but I can say it's not just a matter of me making an executive decision as Attorney General. There are other parts of government that would have to be on board. Well, I'll withdraw that. Have to explore the onboarding of other parts of government before something can be done.
Well, is that in train? Are there...
That has been in train.
Has been in train? Is that in train?
I've had discussions.
Well, can you undertake to give the families as detailed an update as you can within a matter of days rather than weeks? They have been contacting me through their representatives, through Jumbana, whose work I acknowledge in this space, hoping for something other than a vacuum from the government. can you at least undertake to give them a very clear update and some kind of reasonable time frame that at least they may be able to hold the government to account on?
I will endeavour to provide them with an update within weeks. I can't put a time frame on a substantive response, and I can't go into the detail of who has said what within government.
Do you think it unreasonable that the family get an unambiguous apology from the state of New South Wales? The families get that, an unambiguous apology from the state of New South Wales as at least the start of a measure of restitution for what they've been through?
I don't want to preempt what is in a substantive response, but certainly, and now I've met them several times. I've gone up there as well, not to Bowerville, but to Coffs Harbour. I can't imagine what it must have been like for those families, what they have been through. And I acknowledge their extraordinary patience in the last 12 months and their resilience, but I can't preempt what might be in a whole of government substantive response.
Attorney, it's not just the mums and dads and brothers and sisters. It's now the nephews and nieces, and this intergenerational trauma is being handed down. They deserve a rapid resolution as best you can to at least this part of this ongoing appalling saga that they've been through. Do you accept there's that obligation on the state government to, as rapidly as possible, with as much justice as possible, end this element of their ongoing deep problems with the state of New South Wales?
I do.
We were exploring the Marrickville legal aid. Is it true that something in the order of $340,000 was withdrawn from Marrickville Community Legal Centre as a result of that determination?
Mr. Shoebridge, the exact number I'd have to take on notice, but I'm advised that the program that Marrickville Legal Centre was involved in with the 3 other community legal centres was ceased on the 1st of July 2021, and the funding was reallocated by the government to the other 3 legal centres for this financial year.
Well, the funding to the legal centres under that arrangement had been in the order of $170,000 to each legal centre over each year. So them having that taken from them last year and this funding this year, that's where I came with a figure of $340,000. Does that reflect your general understanding of the matter?
I'd have to take on notice the exact numbers, the exact figure of the funding that was allocated to all 3 or all 4 legal centres prior to the 1st of July 2021. But I can say that the pilot itself was reallocated, the funding for that pilot was reallocated after the 1st of July 2021 for the remainder of the 3rd and final year.
Was Marrickville Legal Centre also required to pay back $85,000 of unspent monies from the first year of operation?
I'd have to take that on notice. I'm sorry, Mr. Shoebridge.
There was a KPMG report commissioned in relation to the matter, is that right?
That's right.
Will you table a copy of the KPMG report? I'll probably actually ask that of the attorney. Will you table a copy of the KPMG report, attorney?
I'll get advice on that. That would be my present intention.
Can you explain, attorney, why legal aid has issued directions to not disclose the report?
I'd have to take that on notice.
Can anybody from legal aid explain that here today?
I'd like to take that on notice, Mr. Shoebridge.
Were you aware of the direction to not disclose the report?
I wasn't aware of that direction. at this, but I will take that on notice and I will provide advice.
Did the report make adverse findings against Marrickville Legal Centre in relation to the funding that was withdrawn from them?
The audit was commissioned in order to review the accounts of Marrickville Legal Centre after concerns were raised about the way in which the funding was governed by them through their accounts. So that audit was in relation to concerns about their books, essentially, and the findings resulted in the discontinuation of the program in terms of it being allocated across all 4 legal centres.
Well, in terms of it being allocated across all 4 legal centres, did the findings make adverse conclusions against Marrickville Legal Centre in relation to this funding?
I'd have to take on notice what the exact findings were, but as a result of that KPMG audit, the funding was discontinued.
I haven't read the audit, but it's my understanding it largely vindicated Marrickville Legal Centre and challenged some of the adverse imputations that had been addressed to them by legal aid. Can you tell me if that summary is right or wrong?
Can I take that on notice, Mr Shoebridge?
Attorney, will you undertake to review this matter?
I will undertake to review the matter. What I in substance do will depend on what the results of that review are.
Well, you see, Marrickville Legal Centre provides an essential legal outreach, including to advice on to recent migrants and refugees, and taking more than $400,000 of funding from them over the last 2 years is a very serious matter. Were you briefed upon the decision to take that from Marrickville Legal Centre?
I was, and I think an important point to make is that their core funding and ongoing relationship with legal aid is unaffected, and the quantum of funding for this project is unaffected. What has changed is instead of being a 4-way joint venture, including Marrickville as the lead CLC, the same services are being provided, the same quantum of investment is being made, but it's by three CLCs rather than 4.
Well, Marrickville picked it up midway through, didn't they? Because there'd been problems with the initial way in which it was directed through another legal centre. And Marrickville were in the unfortunate situation of picking it up halfway through, weren't they?
I don't know whether that's true or not.
Were you not briefed on that?
Well, I received a brief about this issue. I don't recall what I was told about whether Marrickville was a lead agency from the word go, or whether that's something that happened over time.
Can you undertake to... Well, what we try to undertake. Attorney, could you seek through those officers that will be here this afternoon to get an answer on the disclosure of the KPMG report today, if possible?
I'll do my best.
Where are we up to on Opcat?
So there's still a bit of a standoff on Opcat. The Corrections Minister might be more familiar with it than I am. New South Wales supports Australia being a signatory to Opcat, but to the extent that it imposes a greater expectation about custodial services in New South Wales, we say that any extra initiatives that should be undertaken should be at the expense of the Commonwealth and not the state, and there is still that impasse.
Well, when you say impasse, has the Commonwealth flatly refused to pay for the extension of oversight to New South Wales to comply with our international obligations on preventing torture?
Can I take that on notice so I can give you a more specific answer? But broadly speaking, my understanding is that the Commonwealth declines to pick up any bill there is for recalibrating oversight, etc., of custodial services in New South Wales.
Have you sought a review or any kind of an assessment about whether or not if not total, but very substantial implementation of Opcat could be done by strengthening the statutory independence of the Inspector of Custodial Services and strengthening the independence of the Inspector's funding without significant additional cost?
I'll have to take that on notice. I have received briefs from time to time on Opcat, but the primary portfolio responsibility rests with the Minister for Corrections.
When can we expect a response, or are we just going to have an indefinite standoff and therefore a continued failure to implement Australia's international obligations to prevent torture?
Look, it can't go on indefinitely because sooner or later there will be Opcat inspectors who will want to come here, and I think that will bring the issue to a head. They were going to come here a year or more ago, and COVID postponed their arrival.
Have you been given, or has the New South Wales government been given any notice of international Opcat inspectors intending to visit Australia and New South Wales?
Well, we got notice over a year ago, I think, and then those Opcat inspectors, because of COVID, cancelled their visit. We didn't cancel their visit; they cancelled their visit. But to update you, I'd have to take that on notice.
Can you table with that notice any communication you've had in relation to those Opcat visits?
I expect so, but I'll get advice.
Mr. McBride, you were giving some evidence earlier about there being one 11-year-old who had, I think you said charges completed or criminal proceedings completed. I'm failing to remember the exact form of words. Perhaps, you could remind me of what the form of words you used were for that one matter for an 11-year-old.
I'm not sure what you're referring to, Mr. Shoebridge. So,
in relation to criminal proceedings and prosecutions against 10 and 11-year-olds,
yes,
you indicated that there had been some 18 matters finalised and completed against 10 and 11-year-olds, and then you gave a separate category for another matter involving an 11-year-old.
So I gave you figures in two categories: charges proven and charges brought and finalised.
All right. And was the charges proven the one case, the one matter?
I'm sorry.
I'm more than happy for you to revisit your notes on it, Mr.
Sure.
McBride.
Give me just a second to remind myself which note.
54.
Thank you.
I'd hand you my note, but it doesn't shed a lot of light, and I'm not entirely sure anybody other than a hieroglyphics expert could read it.
What are we talking about?
I don't even bother to make notes.
We're talking about minimum age of criminal responsibility, aren't we? Great.
Oh, I'm now deciphering it. It says proved 11 years 1.
Yeah.
Yes.
What was the charge?
Okay, I think I can tell you the category of charge. So, proven charge. It was a theft or related offence as the category of charge.
Okay. And that was the only charge proved in that 12-month period against a 10 and 11-year-old?
My advice is that was the only charge proved, yes.
Attorney, reflecting on that evidence, that the only charge proved against a 10 and 11-year-old in that entire 12-month period was a charge of theft, accept that there's something going wrong with our criminal justice system when it comes to kids aged 10 and 11. What are we doing charging an 11-year-old with theft?
Look. Unfortunately, I can't preempt where the meeting of Attorneys General will land, and I can't preempt where Cabinet will land. On the one hand, you could say, well, why are we bothering prosecuting 10 and 11-year-olds if there is such a small number? I suspect, on the other hand, the police will say, or some police will say, in extreme circumstances, we have to expose some kids to the criminal justice system, not because we want to have a criminal record for them, not because we want them incarcerated, but it is a way to get court-ordered diversion. Now, I don't know the difference between 18 on the one hand whose charges were finalised and on the other hand the one where there was a proven case. I don't know how those 17 are made up. I'd be speculating, but I imagine you could argue the toss both ways. You could say, why are we bothering to prosecute 10 and 11-year-olds where you get one charge of theft, which is potentially not a very serious charge, but on the other hand, others will say it's a way to basically bring kids to diversion that they otherwise might avoid.
But the whole purpose of the Raise the Age campaign is to get to that diversion, to get to that intervention.
That's right.
Without taking kids to court. That's the whole purpose. If the only explanation for why this is happening is that's the only way to get the services to help some of the most marginalised and needy kids in the state, well, doesn't that confirm the problem and confirm the urgency?
Well, I'm not putting my own case. I'm putting the case that I imagine would be put. And related to that, if we are to raise the age and have some alternative diversion mechanism in place, then you want to be sure that the diversion is somehow can be mandated, and that if you are getting rid of a court mandating of diversion, that there is some other mechanism in place. So rather than having a theory, let's divert these kids because we know that therapeutically it's much better. You know, their cognitive abilities aren't fully developed and potentially until they're 25. It's not just a matter of saying have some alternative mechanism in place, but making sure that that alternative mechanism is and will be picked up. So that's the challenge.
Yes.
To substitute for court-ordered diversion in extreme cases, and we're talking about the most extreme cases. The vast majority of young offenders will be dealt with under the Young Offenders Act and not through this process. So in these extreme outliers, we've got to make sure that if there is to be some raising of the age, there is some element of mandating or compulsion or assurance that these kids are going to get that diversion and not it's not a kind of opt-in situation.
So, Attorney, why don't we start building that now?
Well, that's what the MAG process is about, to develop a model of potentially raising the age of criminal responsibility to 12, to know what that model looks like. So when attorneys general and cabinets around the country decide to raise the age or not to raise the age, they have a very clear understanding of what the alternative mechanism is for dealing with 10 and 11-year-old offenders, and that's likely to produce results.
Attorney, on a totally different matter, victim services used to publish annual data profiles, but they ceased doing it in 2017-18. And instead we get very, very minimal data published in annual reports. Was that a conscious decision to not publish victim services data? And if so, why?
It's certainly not a conscious decision by me. You know?
I am not aware of it being a conscious decision, but it's just the way that the data is reported now is through the annual report. That's just.
But with almost none of the detail that used to be there in the annual reports.
I can't. I wasn't.
Did it just happen by accident that 90% of the data no longer gets reported?
Not being in the role at the time, I can't answer that, but I can come back to you.
Mr. Shubridge, we're happy to take that on notice
All right.
and report back.
And Attorney, could you also indicate whether or not you'll be reinstating that comprehensive reporting that used to happen at least up until 2017-18?
I'll certainly respond to that in question.
Okay. I think we've...
You have the last 2 minutes, Adam. I'll just give it to you.
Okay, thanks. Thank you. Mr. Attorney, do you have an update on that question I asked you earlier about the Crown Solicitor's timing of her advice to the police?
Ms. Smith?
Yes, so 28th of October.
28th of October last year?
2021.
Okay, thank you very much. Mr. Attorney, what's been the impact of the floods on the court system? I know that, for example, Lismore and Casino Court will be operational, won't be operational next week. Morelanborough and Kyogle, I think, are going back online. You know, how many cases are being deferred as a result of the dislocation across the system? I assume Western Sydney is also impacted.
Yep. Mr. O'Reilly?
Sure. The situation has improved. Last week we had 10 courthouses that were closed, and they were mainly in the north. They were Maclean, Kempsey, Lismore, Ballina, Byron Bay, Murwillumbah, Mullumbimby, Casino, Singleton and also Windsor. This week the situation is better. We have only 6 closed. Casino and Lismore are the most seriously impacted. Maclean, Mullumbimby, Murwillumbah and Kyogle are also still closed but will be open soon. There are other courthouses around the state that have very minor impact, but business is still running as normal. And in Western Sydney, the impact is not significant at all. We haven't yet calculated the impact on the backlog, or have not yet calculated the backlog, because right now our staff and magistrates in the main, as well as district court judges in those areas, are, to be frank, flat out managing
I understand.
the adjournments and the interlocutory matters as best they can using AVL. But once there's some breathing space, there'll be an opportunity to calculate the backlog impact.
That
How much
sounded a
more I
lot
could
like.
ask?
Was that it?
Well,
Sounds a lot like time.
It does sound an awful lot like time, unfortunately.
Does the government have any questions that they wish to put to the attorney or any of the officials here?
Thank you, Mr Deputy Chair. Good afternoon, Mr Attorney.
Good afternoon.
Thank you for your contribution today. Did you have any final comments or any additional information you wish to provide this committee before the session concludes?
No, I just thank everyone for their interest and their incisive questions. Thank you.
Thank you.
I'll take that as the closing of the government's interrogation. Attorney, thank you, and to all the officers who are here. A number of questions have been taken on notice. To the extent that any clarity can be provided during the course of today's hearing, we would greatly appreciate that. But otherwise, the obligation is to provide answers within 21 days. I can indicate for the officers who are here, apart from yourself this afternoon, there is a chance we may conclude by 3:30 this afternoon. It depends upon the efficiency of questioning and the efficiency of responses. But
No undertakings are being given here.
so no undertakings are being given, but we will endeavour to do that. And with that, we'll conclude this morning's hearings.
Thanks, everyone.
Thank you.
Chair,
Thank you. Welcome back to the afternoon session of PC 5, examining the portfolio of the Attorney-General. Mr Tippel, I wanted to explore a matter that has arisen earlier in budget estimates, in other estimates hearings, in particular local government, and it relates to the disclosure made by the Hawkesbury City Councillor Sarah Richards. The matter was raised in budget estimates, and I believe from newspaper reports that Mr Castle, the Secretary of Department of Planning, had taken on board that issue because OLG, I think, falls now within DPE. Mr Shoebridge read out an extract from the Electoral Commission handbook which said that the Electoral Commission didn't have a role to play in determining whether or not any claims or statements made in candidate information sheets are factual. And so on the basis of that, Mr Castle said, they would investigate. Now, according to today's media, OLG has indicated that it doesn't have any role in doing that. So I guess the issue is, does that mean that it was the Electoral Commission after all? And is that something you can take on notice and investigate?
Thank you, Mr Searle. I do not have a great deal of, knowledge of this matter, but I'm certainly happy to take it on notice.
Yep, that's
and
okay.
report back to the committee.
Yep, for your benefit or information, it relates to, I guess, the veracity of claims made by candidates for local government. You have to make certain declarations.
Yep. Sorry, Mr Searle, I gather that
Ms Boyd might have something to say.
may be able to assist.
Oh, excellent.
I'll just clarify for the committee's benefit. I'm here today because the Department of Premier and Cabinet supports the Attorney in relation to the electoral legislation and other legislation that he jointly administers with the Premier. The Electoral Act and Election Funding and Disclosures Act are two of those acts. It is an offence to knowingly make a false statement in one of those candidate information sheets, and the Department's understanding is that the Electoral Commission is responsible for investigating and enforcing offences relating to New South Wales elections.
Yeah. See, there was an earlier iteration of this in relation to Mr Douay, who was then the Mayor of Strathfield. It was about the veracity of his declaration. Now, my recollection is OLG did investigate, and they did refer that matter to what used to be the Local Government Tribunal. I think it's now part of NCAT. So I'm just trying to get a line of sight of, as I know because I was a candidate for local government a few times and I had to make certain declarations, and if those declarations prove to be false, whose job is it to enforce them?
Well, the Department's position would be that is, strictly speaking, the Electoral Commission, but there may be views that the Electoral Commissioner has in relation to that you might want to test with him.
Oh, might have to call him back to a special hearing. I will cede the chair now to the chair, who has
doing such a good job.
No, happy to happy to keep questioning, but we'll move on to a different issue in relation to. So you'll take that on notice and you'll come back to me.
Yes, Mr Searle.
I just, I just want to make sure I'm asking the right person the right questions, or to whom these should apply. All right, so there's that. Now, in relation to the last couple of years, we've had a difficult couple of years with COVID and now obviously floods. Unusually for a budget estimates hearing, I'm actually going to refer to the budget papers briefly. Budget paper number 2, pages 7-11, 712. Essentially, the information there is that there were about 25,000 cases deferred in the local court because of the pandemic. I was just wanting to see if there was a line of sight on whether that backlog has been able to be addressed and where that might currently be up to.
Yes.
And if you could divide it between civil and criminal, and
I'm very happy to take that question, because the matter of the continued operation of the courts through the various exigencies with COVID has been a challenge. We have worked very closely with the various heads of jurisdiction, but obviously that includes the Chief Magistrate. just at high level, so what I might do, Mr. Searle, is deal with high level, then drill down, and then if your question goes to the specificity of the response to COVID and the manner in which the court has dealt with that, we can also respond to any questions on that. But the data I have at very high level through to from October, and this is box art data, I should stress, running from October 2022 to the end of September 21, compare with the 12 months prior, is that in terms of the criminal caseload of the local court, registrations increased by 2.2%, finalisations increased by 13.4%, which is about 23,000 matters. Registrations just outpaced finalisations by around 200 matters, equating to an annual clearance rate of 99.9%. The clearance rate during the previous 12 months had been 90.1%. I can talk about processing time if that would assist.
Yeah, not so much. I was just more interested in what is the outstanding backlog from the 25,000 that were dislocated because of COVID, and that's the figure in the budget paper number 2,
right,
page 7-12. Just wanted to see whether or not, and I'm happy for you to take it on notice if you don't have it, because again,
well,
I just wish to stress this is not a gotcha moment. It's just.
I gather that my colleague, Mr. O'Reilly, is very keen to add.
Well, very, very keen and interesting choice. I can certainly talk about that backlog. It's reduced, the COVID-related dislocated backlog you described. The current reading on that is 11,000 sentence matters and 8,000 defended matters.
Okay, so that's 19,000 all up. So down from, so you've got it down for by about a third or a quarter.
Yeah, as well as having a very high clearance rate for the incoming work.
No criticism. I look on the record. The local court is well known as a very hard-working and efficient jurisdiction, and so there's no criticism of the court. I'm just trying to get a handle on the issues.
Sure.
There is mention in the budget paper about new investment in additional magistrates in the current budget, and I know the attorney has made a number of appointments, but I think that there are still 7 vacancies outstanding on the local court. Is that correct or not correct?
Not quite correct. So there were 8 positions as part of that decision. 4 of them are already in place and working, and the other 4 are due to be in place through this month and April. So the 8 will be in place by April is the plan.
Okay, and that includes any filling of any vacancies in the previous establishment?
Yes, but we are anticipating some retirements after that period, so that'll have to be managed as well.
Okay. One matter that I have pursued on a number of occasions, including in my current role as chair of the inquiry into the coronial jurisdiction, is the resourcing of the coroner's court. Now, I understand there was about 5.2 FTE coroners who were magistrates, but I understood that was to be increased to 6.2 in the near future. Has that occurred?
There are 6 full-time coroners and 2 part-time positions, roughly 1 day each per week.
Okay, that's good. So, in relation to the backlog in criminal trials in New South Wales, how many trials in each of the district and Supreme Courts have been delayed as a result of the COVID situation, or indeed any situation?
So I can describe the backlog implications. It may not be in exactly the terms you put the question, but I'll have a go.
Look, I ask the questions. You can answer in any way
and if we haven't
wish to, and we have any differences,
we can follow up.
Yep, absolutely.
Okay. And I should say that a lot of these, this summary of numbers, backlog and forecasts for when we'll have it resolved, uses indicative numbers that have to be verified. So they're subject to review as we get more information, as the numbers firm up. But this is the best information we have at the moment.
Of course.
So in the district court, the number of pending trials has increased from the pre-COVID period when there were 1,389 pending matters. It's now 1,625, but I should say in the lead up to COVID there was a huge reduction due to some heavy work undertaken in the court. So there has been an increase in pending matters in the district court. that's likely to return to those pre-COVID levels in between December 2023 and December 2024 is the current forecast based on indicative figures that could be reviewed. And that will depend on what happens with the current outbreak, I guess. So if we get back to normal business in, say, April or May, we anticipate around December 2023, we'll get back to pre-COVID levels. But if there's another, say, 3-month delay, it would be longer than that.
Okay.
That's the best possible.
And can I just add, one of the peculiarities to the embedded in the data through this period has been that the court has had to variably respond to the different waves and outbreaks. So in June 2020, the Chief Judge directed that from June the 1st, in-person appearances would be permitted for particular matters, but still subject to the discretion of the judge. And obviously, online virtual court appearances were still encouraged. But then, as of the 17th of January this year, in-person appearances were again suspended. So it's been a variable pattern since COVID started 2 years ago.
Yeah. Do you have any data on, of those matters that were put into the backlog, how many of those have been able to have rescheduled trials?
I can certainly describe how many were vacated and how many we've picked up again.
Okay.
But whether it's a direct line, I'm not sure. But
okay.
Our estimate is that around 500 trials were vacated in the district court through the entire COVID period. But since jury trials recommenced in October, 25th of October 2021, in between October and the end of the calendar year, the end of the term, 100 trials were commenced. And then since the law term began again in January up to now, a further 145 trials have commenced. 72 of those are completed. And occasionally we will cancel one because there's been an impact of COVID that impacts on the jury. But,
yes.
But the pickup has been quite good since October, taking the Christmas break into account. That's 245 that have been reactivated.
Okay, so nearly half?
Yes, yes.
Okay, that's good.
Roughly speaking, yes.
Yeah, okay. And working at that level, then should we expect that the backlog to, all things being equal, to be essentially ruled off by the end of the year or middle of next year?
No, as I said earlier, we're using the pre-COVID backlog or pending caseload as the target to get back to that, because you may recall in the short years before COVID-19 there were some reforms which really supported the district court to achieve a big cut in the backlog, and that's the improvement point that the district court is seeking to get back to. Okay. And so again, depending on when we get back to normal, the best estimate we have now, subject to review, is between December 2023 and December 2024.
Okay. And what about the Supreme Court? What are the equivalents for there?
So the Supreme Court, and I'll talk about criminal, civil, and the criminal appeal and the civil appeal categories. So in the criminal jurisdiction in the Supreme Court, efficiency is improving. There are 128 pending matters at December, which is 4.5% less than the previous year. In 2021, Supreme Court completed 42 trials, jury trials, with a further 34 scheduled between now and August, so they're really getting through the work. In the civil jurisdiction, 6,185 pending matters at December, which is actually an increase on the previous year, 6%. 219 pending matters in the Criminal Appeal Court, which is an increase on the previous year. And the Civil Appeal Court, we have 165 pending matters at December, which is 2.9% less than the previous year.
Okay. Do we have any idea about how many people, how many defendants are being kept on delayed remand due to the backlog in the criminal trials?
Not with me.
No, I'm happy for you to take it on notice.
Take that on notice, Mr. Sell.
I'd also like to know, if we do know, what the average length of that delayed or extra remand time occasioned by the backlog for each of the courts that you have the data for. That would be very useful. There seems to have been, at least amongst judicial officers, mixed views about the efficacy of the online hearings. Some judicial officers have said it actually has improved things in that they've been able to watch people's demeanour, I think some of them have managed to record it themselves, so they've been able to play things back and slow things down and, watch witnesses in more detail than they're able to in an in-person hearing. Others say it's no good in terms of evaluating, credit and candour and those sorts of, difficult issues, particularly in, matters of contested evidence or, obviously criminal trials being the really good example. Has any consideration been given to evaluating some of the COVID responses of necessity to sort of work out whether or not the adaptations to the legal system have made things maybe less fair or more fair, or what the impacts have been?
I should, in a moment, refer that question to Mr. O'Reilly, who can give perhaps a more granular response than I, but I can certainly indicate that amongst the heads of jurisdiction, which I have spoken, there's a real interest in when things normalise, actually having a look back at the learnings and what it has meant. So I think there is a willingness to interrogate those questions, but nothing, to my knowledge, formal has been instituted at this stage.
Okay.
That's true, and part of that is our role as the administrators or the supporters of the judiciary in running their courts. So we do have a program of digitising a lot of the processes and improving video linkages and the tools to support that. We've accelerated some of that in response to COVID because that has allowed us to keep matters moving where it is appropriate to use video link and similar technology. And we'll keep that work going, but all of it is done in consultation with the judiciary who clearly have views about that. We've been doing that work. It's progressing now, but again, a bit similar to one of my responses before the break, we really are focused on the doing at the moment.
I appreciate that.
Yeah, because some, as you appreciate, some court lists are hundreds per day, and if we lose a day in a court, it's really a lot of work to reorganise all of that. So the focus is on the doing, and we will shift to the measuring and evaluation shortly, but that would really be done hand in hand with the head of jurisdiction.
No, look, that's really good to hear, because obviously it's a matter of great interest, I guess, not just in the legal
and investment too. There's big investment in that, so we need to make sure that it's the right move and that it's used in a way that supports the system and court users.
Certainly. Mr. Tidwell, at previous budget estimates, the then acting Secretary of the Department, Ms. Delia, said that some of the things that government was doing to address court delays was to possibly look at renting additional office spaces. Was any additional spaces rented to deal with either backlogs or... Mr. O'Reilly, you're probably the best person to direct the question to.
We did rent additional space to support the resumption of jury trials in October, because we needed space that was adequate for running rapid antigen screening in a way that had enough physical space so people could come report to the court, go to the room that had been allocated for rat testing or rat screening, and then once they'd come through that, they'd then go to the impanelment process for juries. In some locations, the courthouse has space for that, and in others, it really doesn't. And a good example is a Downing Centre, where there was a hall hired across the road that was used for that. So a lot of, I can't remember the exact number, but a significant number of venues were hired and remain with us at the moment.
Okay.
So we can keep those trials moving.
So how many extra rooms or properties, or how have you categorised them? How many were rented and for what period of time?
From October, and are still being rented.
Okay.
And the exact number, I couldn't tell you. It is less than 20, I believe, but I'll come back to you with the exact. I'll take that one on notice.
Sure. And is it only in the CBD, or are they
mainly in the CBD?
Okay, mainly in the CBD. Not at any of the regional, not regional, but like suburban.
Yes.
Like you've got the Justice Precinct, for example, at Parramatta. Is that one where you might have?
I believe there's enough space in those buildings already. But the juries in the District Court, for instance, have been running in 16 locations around the state. So we have hired venues in a number of locations to support that. But it might be better if I take it on notice and give you the list of locations.
Absolutely. So the leases are still in place. That's good to know. Until, did you say October?
No, since October.
Since October
and
until...
we would work with the Chief Judge of the District Court to navigate that and work out when they're no longer needed.
Okay, and so these are only for District Court matters?
Yes.
Have you had to do the same thing in terms of, providing extra spaces for rat testing and the like for either the local or the Supreme Courts?
No, and there are,
space?
well, in some places, or in many places, both jurisdictions use the same facilities, so we've been able to do that. But the main thrust of additional venues was to support resumptions of trials in the district court. That was the main reason for it.
Okay.
Can I just supplement,
Please.
if I may, because under this, sorry.
You can answer.
I didn't see the chair.
Yeah.
Re-enter.
No, that was a
Finish-
direction to
finish
him.
answer.
The
Right.
answers are in a separate time of their own.
The performance of NCAT has been notable just in response to your question through this period. So NCAT moved to conducting all stages of its hearings by phone as of the 30th of March, and face-to-face hearings are only conducted with prior approval of the President. And at this stage, that's continued through till now, but NCAT curiously has had a clearance ratio of 102%, which indicates that
They're getting on top of the backlog.
They're getting on top of the backlog.
There's no notable backlog from COVID in NCAT. It's really been very efficient.
Follow that up later.
Mr. McKnight, I'm sorry to go back to this data set. I should have asked a series of questions all at once.
Sure.
But we're going back to the data set about criminal proceedings against 10, 11, 12 and 13-year-olds.
Absolutely, and I can answer one of the questions I took on notice earlier if you're interested in me doing that.
Indeed. Thanks, Mr.
Let me
McKnight.
let me just find my note. There's so many notes. The question you asked that I took on notice was how many children in the age group 10 to 13 had entered sentenced custody.
Yep.
The answer is none in all those age groups.
All right. So the only time children have been in jail in New South Wales is when they're being held on remand. Children
in that
aged
age
10
group.
to 13.
That's right, yeah.
All right. Obviously, there are observations on that, but it doesn't feel right asking the opinion in the absence of the minister here.
Well, that would probably call for policy.
I think it might. In terms of the children aged 10 to 13 who were held in detention, all on remand, it appears, do you have a breakdown in terms of their, to the extent to which they were identified as Aboriginal and Torres Strait Islander?
I do.
Could you let me know?
I can. So there were two data sets I gave you, a data set of all admissions and a data set of unique admissions.
Yep.
For all admissions, there were no 10-year-olds who entered remand custody. For 11-year-olds, there were a total of 9. One was non-Aboriginal, 7 were Aboriginal or Torres Strait Islander, and 1 was unknown.
All right.
For 12-year-olds, and we're still in all admissions here, there were 72 in total. 13 were non-Aboriginal, 56 were Aboriginal or Torres Strait Islander, and 3 were unknown.
I'm sorry, Mr. McKnight, I think I misrecorded the data for the 11-year-olds.
It was 9 total, 1 non-Aboriginal, 7 Aboriginal or Torres Strait Islander, and 1 unknown.
Yep. And then for 13-year-olds?
So you'll recall the total was 212.
Yep.
Non-Aboriginal, 101. Aboriginal or Torres Strait Islander, 96. And unknown is 15.
All right.
And then for unique admissions, so the numbers here are lower.
Yep.
Again, 0 for 10-year-olds. For 11-year-olds, you will recall the total was 6.
Yep.
For non-Aboriginal children, that the number is 1. There were 4 Aboriginal Torres Strait Islander children who were 11, and 1 unknown. For 12-year-olds, the total is 25. For non-Aboriginal, the number is 9. Aboriginal or Torres Strait Islander children, 13, and unknown is 3. For 13-year-olds, the total is 107. For non-Aboriginals, the number is 52. 44 Aboriginal or Torres Strait Islander children, and 11 unknown.
All right. I think we can safely say, can't we, that that is a grossly disproportionate representation of First Nations children being held in prison on that data?
The overrepresentation of Aboriginal people in the criminal justice system is real, yes.
Mr. O'Reilly, in terms of the court data and the overrepresentation of children in the children's court, do you have any data about that?
Not with me, I don't believe. No.
Is it available? Is children's court data broken down into defendants being First Nations and non-First Nations?
I'd have to check that for you.
It would be.
Could you, on notice, Mr. O'Reilly, give a breakdown, if you can, by offence category or by offence for children's court, based on whether or not the children being proceeded against identify as Aboriginal and Torres Strait Islander or not?
Certainly.
And could you do that over the last, if you could, the last 3 financial years, if that data is available?
We will.
Right. In terms of victim services, who do I direct those questions to, Mr.
To me.
Oh, you again, Mr. O'Reilly?
Yep.
Do you know how many internal and external reviews were lodged or have been lodged this financial year to date?
I believe my number for reviews ends in June, but I'll just double check that. Yeah, it goes up. It's 2021. I don't have any from July to December.
All right. And is that going to be the situation for pretty much all data requests I make about victim services, Mr. O'Reilly?
No. I'll have some data up to December, but not that particular one. This was asked in the supplementary questions in November.
Indeed.
And the data's in the response to that.
All right. The one of the questions that we asked in supplementaries was about the consultation that was undertaken when there were changes to victim services policies, and what consultation was undertaken with victims and survivors. I could read on the answer to that question, but it'd take some time, and it just generally spoke about generic consultation. Do you have a policy in place when changes are proposed to be made that have significant impact on victim services? Do you have a policy that requires you to undertake consultation with victims and survivors to endeavour to understand what the impact will be?
I'm relatively new to this portfolio and I've not implemented such a policy, but I am aware that the position is that we, or the victim services team, and we will use the victims advisory board, which is the board established with the Attorney General, and also the Victims of Crime Interagency Group, which includes government agencies and various peaks and legal centres. We'll use those groups to consult.
So, apart from those groups, there's no outward reach to the thousands and thousands of victims that have come through?
There certainly has been. I've certainly been told about contact that our staff have had with victims in relation to changes, but not aware of any particular process.
Mr. Riley, can you provide on notice the number of internal and external reviews from 1 July 2021 to date?
Okay.
Yep. Can you also advise how many appeals have been made to either the Supreme Court or the Court of Appeal from determinations of victim services for the same period?
Yeah, on notice, yes.
Can I indicate one of the reasons I'm asking these questions is because all of this data was available at a very granular level up until 2018, financial year 2018. And so there's enormous frustration in the sector that they have no transparency on what's actually happening, or minimal transparency on what's happening at victim services. Has that frustration been communicated to you, Mr. O'Reilly?
Not me personally. I've been in this role for a short period and it has not been communicated to me. But as I said in a previous response, this change in the way data is presented publicly happened before I arrived, and we'll have to come back to you with possibly with a rationale that's around why it happened.
Oh, sorry, Mr. O'Reilly, I didn't mean to talk over you. Mr. Tibble, there are various obligations under the Government Information Public Access Act, various general principles there, effectively requiring government agencies to proactively publish data and information such as this. Will you seek a review about whether the GIPA Act principles have been complied with in relation to victim services data, noting that reduction in publication of data in the last 4 years?
Yeah, I hear your concern, Mr. Shoebridge, and I'm certainly happy to, I'm certainly able to commit to looking at the application of the GIPA Act, but going to the spirit of the question, it is apposite that there be appropriate transparency and data available to indicate the performance of the scheme, and I have taken that out of this morning's questions as well.
You see, Mr. O'Reilly, I've got pages and pages of questions seeking effectively the data that used to be published. And we could spend the time going through that because of the frustration the sector have found. And I don't blame you for it, noting when you came into the position.
I understand.
But we could spend the next, we could wait after 3:30 going through these questions. But a far more effective response would be a kind of institutional response to reflect upon this and seek to provide as much transparency as possible. I think I've got that.
I hear that, Mr. Shoebridge, and I'm happy to commit to looking at the appropriate reporting framework for victim services.
And just so there's no ambiguity about where these concerns come from, as a result of changes that have been made in the last few years to victim services, there's now a far greater onus on victims of crime to present their own evidence, to do it in a 12-month time frame. And the sector that have communicated with me on multiple occasions say that this particularly impacts victims of domestic violence and sexual assault crimes, who are often not in a position to present that. And they want to be able to see what's happened to those categories of offences and see if they are getting fair access to victim services. So I just want to be clear, it's one of the primary concerns that we have in this space. Have those concerns ever been raised with you, Mr. O'Reilly, about how particular categories of offenders have particular difficulty navigating the victim services system?
Not personally to me, no. But that, again, it's been a short period, and a lot of that was the Christmas shutdown, so it's probably just a question of the time frame.
Ms. Boyd?
I'm not questioning the proposition.
No. But could I ask just for a response from you, Mr. O'Reilly, and you, Mr. Tidball, about what, if anything, we can expect in terms of timing of review or the provision of data, if you could take that on notice?
Certainly, and I should just make the point that Victim Services is not a stand-alone agency. It's part of DCJ, so it falls directly within my responsibilities. I would be prepared to commit, and I'm looking to Mr. O'Reilly when I say this, to provide a substantive, to look at this carefully over the next quarter.
All right, thanks, Mr. Tidball, I appreciate it. Ms. Boyd, did you manage to identify what, if any, communications had gone from DPC to the Commissioner?
I did. DPC did not write to the Commissioner. The Commissioner is employed by the Minister for Police. DPC writes to the heads of agencies that are employed effectively by the Secretary of DPC. So the Secretary of DPC will write to all of the department secretaries, inviting them to make their annual declaration in accordance with the Public Service Commission's direction. The DPC Secretary will also write to office holders within the DPC cluster who are not required to make the declaration, but inviting them to do so voluntarily. Given that the Commissioner for Police is not appointed or employed by the DPC Secretary, there is no routine communication to that office holder in relation to annual declarations. But of course, DPC encourages all public officials to, make regular written disclosures, and that is best practice.
The Code of Conduct is unambiguous in this regard, requiring the Commissioner of Police, as well as a number of other separate agency heads, to provide the disclosure to DPC. You're aware of that, and I'm happy to read out the section from the Code of Conduct if you require that.
I think that if you're referring to the Public Service Commissioner's Direction Number 1 of 2015, there may be a bit of ambiguity in that regard in terms of the Commissioner for Police not being identified in Schedule 1 of that direction, but that is really a question of form over substance. Of course, all heads of agencies ought to, make appropriate conflict of interest disclosures, and I think the LEC report, which I did have the opportunity to read over the break, indicates that the Police Commissioner, did make verbal disclosures to his employer, being the Minister for Police, and that those interests were, did not result in any improper conduct on behalf of the Commissioner.
The report that I read, Ms Boyd, said that once, in 2019, the Commissioner made some form of verbal disclosure to the Minister.
Yes.
Are you aware of any verbal disclosures that covered 2017, 2018, 2019 or 2020, apart from that one incident?
No, I'm not aware of any verbal disclosures.
And unless I misread the code and the LEC report, it made it very clear that the obligation was not to provide a verbal disclosure but a written disclosure?
That appears to be the view of the LEC, that there was an obligation to provide a written disclosure, and that it appears that the LEC has looked at the substance of the matter, and yes, while there was in their view, a failure to provide a written declaration, there was no improper, the substance of it was there was no improper conduct. But that is the view of the LEC, and I don't wish to comment or, on the LEC's views in that regard.
What about the Code of Conduct itself that says any senior executive in the Teaching Service, New South Wales Police Force, Transport Service of New South Wales and any other service of the Crown must make a written declaration annually?
Yes, I think...
Contained in, I think, 3.5 of the Code.
Yes, I think that is right, but the Code also specifies that statutory officers are not required to comply with that. And if you look in Schedule 1, there is no reference to the Commissioner of Police in that schedule. So the matter has been raised with the Public Service Commission in terms of clarifying that, because I think we all agree that, everybody in the public service should be making at least annual declarations of their private interests and managing.
Did the head of TAFE make annual disclosures?
I think that's probably a question for the head of TAFE.
Well, they're also employed by the Minister and therefore wouldn't necessarily fall within the agency cluster in the way you say. So has the head of TAFE made annual disclosures?
I'm not aware of that. I think you'd be better off asking the head of TAFE that question.
Does DPC have a register of who's made their Code of Conduct disclosures?
We have records of who within the DPC cluster has made those declarations, and we also have records of the secretaries that have, but DPC is not. I should stress that these obligations rest with the individual. DPC is not an enforcement body or an investigative body. We provide resources and guidance to the sector on these matters, as does the Public Service Commission. But no, we do not have a register per se.
Did the previous Police Commissioner make disclosures in 2015, 2016 and 2017?
I'm not aware of that.
Well, would you make some investigations and advise us on notice?
I will see what DPC holds, but again, because I'm not sure that those would be required to be made to DPC prior to 2015 when the Public Service Commissioner's direction was made. But
Is why I asked you for 2015, 2016 and 2017.
yeah, no, I can go and check, but I don't know.
I'm not expecting you to know now, but you'll provide an answer on notice.
Yes, of course. Yeah.
And including details of when those disclosures were made, if they were made.
Yes.
Is DPC in the process of reviewing how disclosures are made by senior government agencies, or are we just going to continue muddling on like this with ambiguity?
I think that the relevant direction is really a matter for the Public Service Commission, and we definitely have raised the matter with the Public Service Commission in terms of that direction being some years old and requiring some clarification in terms of, which obligations are mandatory and which are voluntary. So that work, I think, is being undertaken, but it might be more helpful for your purposes to ask the Public Service Commission that question.
When did you raise that with the Public Services Commission?
I'd have to take that on notice, but I believe members of my staff have reached out to the Commission to alert them to the matter, and I'd have to check with them about when that occurred.
Well, was this matter raised with you before the LEC report was delivered yesterday?
Yes.
So can you indicate, you can't provide any further detail of whether it was a month ago,
Well,
12 months
in the
ago?
last 12 months. Yeah, it's definitely.
But you'll give details of exact dates as best you can on
Yes.
notice?
Yeah, happy to do that.
Thank you, Chair. Mr. Tidball, I'll ask you the questions, and I'm happy for you to share or refer to your colleagues or take on notice.
Certainly.
I've got a series of questions that are before me. The most recent CSO annual report, 2021, has percentage of people whose first language was not English, going backwards from 16.6% in 2017 down to 11.4% in 2021. What measures are in place to rectify this?
Can I just ask you to repeat, if I
sure.
may, which report was it?
This is the 2021 Crown Solicitor's Office Annual Report.
I believe that I would need to take that on notice, but I know that the...
There's a whole series of them, so I'll ask them.
I think we'll need to take that on notice, yeah.
Well, I'm happy to answer
Respond?
if that's to respond if I can.
Grand Solicitor can respond.
Thank you.
So, absolutely understand the importance of inclusion and diversity, and people from a non-English speaking background is an important part of that. I think there's more work that we can and should be doing, and that's an important part of our people and culture function to expand the diversity of our workforce.
Well, would there be any particular measures that you would be taking to rectify this fall in the number of non-English speaking background workers in the Crown Solicitor's Office?
Look, I think what we're addressing is diversity generally.
Yep.
We've got specific measures in relation to increasing the number of First Nations peoples working in the office, and we're partnering with third parties to assist us to do that. We have got exemptions to be able to employ Aboriginal and Torres Strait Islanders peoples without in preferential treatment where we can. We are the reason for fall in non-English speaking background is difficult to pin down to one particular source. The numbers of people we employ generally dropped by a small amount, so that may be part of it. The mix between lawyers and non-lawyers may be part of it. People's reporting may be part of it, I don't know. But the more diverse workforce we have, the better workforce we will have in terms of representing the people of New South Wales, representing the breadth of our clients and the people. So it's something I personally am strongly supportive of.
Do you reach out to organisations like Multicultural New South Wales, for example, for assistance when you see that the diversity level is dropping in the Crown Solicitor's Office? or any other agency within the government departments?
We certainly liaise strongly with the Public Service Commission and adopt their policies and procedures and take any advice or recommendations that we can get. We have a graduate program. That's our biggest source of new employment for lawyers. It's a widely respected program, and that's where the majority of our new employment comes from, certainly in terms of lawyers.
And do you publish that to, who do you publish it with?
The graduate program, like who do we advertise?
Yes.
We advertise, so we go into universities in law schools.
Right.
We advertise it really broadly. We're really looking to get the best candidates we can and encourage people to come in and work in government.
Well, that takes me to the next question where you indicated a little about the First Nations people. Aboriginal and Torres Strait Islander representation is well below the 3% benchmark and getting worse, falling from 3% in 2016 down to 0.5% in 2021. Again, what measures are you taking to rectify this?
And I think the percentages are very low and affected because they're so low. It's affected by one person can affect the percentage in a big way. But we are looking at having dedicated graduates from the First Nations people. It's really difficult to attract and retain First Nations graduates. They're in high demand. The work we do is really interesting and amazing work, and the more First Nations people we can attract to the office, the better, from my point of view.
Can you tell me how many First Nations people work in the Crown Solicitor's office? I mean, you said one person moving or leaving makes a difference in the percentage. How many are there? Do you know?
I do. It might just take me a little moment to get it for you.
No
but
urgency. If you can, I'm
Yeah.
happy for you to take it on notice.
I think I can get you that answer today, but just let me find it.
Sure.
I don't think time's of the essence this afternoon.
Yeah.
Two.
There's 2 people out of.
So we have around 470 people.
Oh, that's a very small number. I'll go to the next one, and that relates to people with disabilities. There's been no improvement in the overall percentage of CSO staff with a disability of 2.6% in the last 5 years, less than halfway to the Premier's priority of 5.6. So the last 5 years, it's just been sitting on 2.6, and not really. There's no significant any improvement, it seems, to reach the Premier's target of 5.6. What is the Crown Solicitor's Office taking any measures to improve that, to address this issue?
And we have an internship program where we get persons with recognised disabilities to come and work as paralegals or to work in the office, and we're certainly keen to improve the diversity of our employees in that regard.
So if it's not working, are you looking at alternate ways of reaching out for people with disabilities that could work into?
I don't think it's so much that what we're doing is not working. I just don't think it's quick. It's not immediate, and we're coming off a low base, and so it takes time to see results but we certainly are partnering with specialist third-party organisations to assist us both with First Nations people and with people with disabilities, so that we can get people in the door and working for us. And the more people we can get from diverse backgrounds, as I said, the better we will be as an office.
And the reason I ask the question is that obviously the Premier's priorities of 5.6% wouldn't have been plucked out of the air. It would have been based on some figures that would have been achievable to achieve that Premier's priority of 5.6%. It's sitting on 2.6%. So I'm sure there would be alternate approaches to reach out to people with disabilities to be employed in your office.
Yeah, look, I don't know. I think the programs that we have are very good, and the people that we have coming through the programs that we have, they're very good. And certainly we've had really positive feedback from the interns from these programs who are working with us. It doesn't always... They may not always stay, but we'd like them to, and we definitely would like to see more people from different backgrounds working with us. There's definitely more we can do. There's always more that can be done, and there's, if people have suggestions about more things that we should be doing, I'd be very happy to take those on board, because I definitely support us doing everything we can to achieve the diversity targets that have been set.
Okay. Well, the next set of questions to do with mental health. In 2020-2021, CSO engaged a new EAP, Employee Assistance Program provider, Bannister. What were the reasons behind this?
I think we reviewed our existing program and then re-tendered the kind of work that we do means that's very important that we have a strong and effective program that our staff can access.
What were the total number of EAP service requests from CSO employees?
Over what? I'd have to take that on notice, but over what period?
For the last year.
So the last financial year?
Yeah, my question is not specific, but for the last financial year.
Well, maybe 2021
yeah.
and year-to-date 21-22.
And that's the number of EAP requests?
Yeah, EAP service requests.
I don't know that I'll have that figure to hand.
Okay,
but I can take that on notice.
On notice is fine.
And if you can come back on notice if that's an increase on the previous year. And what eyesight does CSO have over changes in employee welfare?
Yes. Oh, sorry. What was
I'll
that
read the question.
Yeah.
What eyesight does CSO have over changes in employee welfare? I guess oversight.
Yeah, well. Yeah, I think it's, yeah. Essentially, what do you do to make sure your employees are safe, well, healthy,
Oversight, yeah.
satisfied?
Well, there's a number of things we do because it's really important. And in terms of what we do, our people are everything. If we don't have a healthy, resilient and engaged workforce, then we aren't able to provide high-quality, cost-effective legal services, which is the purpose of us being here. We have a dedicated work health and safety officer who has responsibilities for work health and safety, and she has put significant effort into COVID safe plans for the office over the last sort of 18 months or so. We have the PMS survey, which measures staff engagement, and we understand that the nature of the work that many of our lawyers are doing means that they are exposed to quite traumatic factual circumstances, and that is a particular work health and safety issue for us to manage.
Thank you, Adam.
Just on those issues, Mr. Tidball, you're the cluster secretary.
Yes.
Obviously you're very new, so there's no criticism, but I'd also like to sort of understand what DCJ is doing more broadly.
Yes.
Because, particularly during the pandemic, I guess you've had a situation where people are not so much working from home, but also living at work. There's been an intensification of work, and my sense is across the public sector, there has been a very significant intensification of work. Like KPIs, throughput. This is a generalisation, of course, but there's been a massive productivity spike, at least initially in that first lockdown. So, one, I'd like to see whether that's consistent with DCJ's experience, and also what is DCJ and the other agencies associated with it doing to monitor staff welfare, to guard against burnout, that sort of thing. So you'll have the People Matter survey results.
Yes.
Those are sort of things that we'd like to sort of start to develop a line of sight on as we hopefully move, I was going to say beyond COVID, but I'm not holding my breath, but at least past these initial 2 rounds of COVID.
Yeah, look, can I, by way of context also, because I think that part of the question of a healthy workplace and wellbeing does turn on the question of a diverse workforce that is being well supported. And one of the things that has genuinely impressed me coming into the organisation, particularly given the role that it has in serving the community and communities across the state, and particularly those with particular disadvantage, is the work that's been done to strengthen inclusion and the inclusion strategy from 21 to 25. Without going into it now, that is a comprehensive document in terms of targets and where that's at. I can speak to that as required or take on notice. In terms of the care for our staff and their mental health, and acknowledging that the work of DCJ staff working with disadvantaged people who are, of course, themselves strained during the COVID period and with the impacts of the pandemic, there will be a trail of that, and the impact of that will become clear in further PMES data as we move forward, and that is something which I could report on. Having said that, I think that the data indicates that there are some positive features in there. What there was, and something in which I've taken an interest as I've met, for example, with child protection teams or the Central Sydney team, is a place of check-ins and heightened risk management. All those sorts of things were factored in. In terms of the formality of that, clearly there was a degree of catch-up because some of this did develop under a very unique set of circumstances. But I would be very happy to take questions at a future hearing as I learn more and as the data becomes more abundant, or if there are specific questions on data available to date, I'm happy to take those on notice.
Well, I'm glad you raised that because I've got some. Consistent with the questions that were asked of the Crown Solicitor, do you have a line of sight on whether the percentage of employees whose first language was not English, whether in DCJ that has gone up or down or stayed relatively the same?
Yes, I do, Mr. Searle, and I have it on me, I believe now. Our workforce data shows that 9.5% of DCJ employees shared that their first language, which is in the last survey spoken as a child, was not English, and the public sector benchmark is 23.2%. Notably, the survey, the PMES, so the People Matter Employment Survey 2021 reported that 20% of DCJ employees completing that survey shared they spoke a language other than English at home, 21%. And we actively monitor improvement in employee engagement scores for culturally and linguistically diverse employees through the survey. The overall employee engagement score for CALD employees was 70%, higher than the 65% score for all of our employees. And I do have some other data which I could keep working through,
that's okay.
and corresponding with disability and other groups as well.
Please tell me about the disability experience and also your First Nations experience. Has it gone up or down like the CSO?
Yes, so if I can firstly deal with Aboriginal and Torres Strait Islander employment. DCJ has, I'm pleased to be able to advise the committee made significant progress in improving the overall representation of Aboriginal people. In 2021, the estimated representation of Aboriginal people is 4.7%, which is higher than the 3.7% sector average in New South Wales public sector benchmark of 3.3%.
Was that up on the previous year or down? Happy for you to take that on
I
notice.
would need to take that on notice, Mr. Searle.
If you could, that's good.
And DCJ has also achieved the New South Wales public sector aspirational benchmark of 1.8% Aboriginal representation in all salary bands, including senior leadership. DCJ has 5.6% Aboriginal representation in the senior leadership pipeline, which includes employees at grades 9, 10 and 11 and 12 and equivalent.
Okay. Getting back to the work intensification issue, both here in Australia increasingly, but also in some overseas jurisdictions, one of the ways in which they've combated the sort of work fatigue, if I can use that, is this sort of this notion of a right to disconnect. In this sense, what we've seen here is this sort of creeping situation where once upon a time the after hours email or the after hours phone call would be out of the ordinary. Certainly in the public sector it has become the norm, and that has led to people feeling, seriously overworked. So this notion of drawing a line in the sand where, at a certain time you're not really expected to answer the phone or respond to an email, or in fact people shouldn't even be sending them after those times. Is that something that you might consider for your stressed workforce?
Can I acknowledge that there's been a generally reported phenomenon throughout the economy and the population about the creep that's happened through the COVID period. Rather than me opining on it now, that clearly is something which I have an interest in that. I'd be happy to provide some subsequent advice on it. It is not something which at this juncture, in all honesty, that I've had the opportunity to
We'll have an ongoing conversation. Mr. Shoebridge.
Thank you, Chair. Mr. McBride, I think I should have had more coffee this morning because I have another question about that data set.
Sure. Let me pull it out. Oh, no, here it is. What can I help you with?
Do you have any data about the longest period that a child was held in detention, a child aged 13 and under? And if you also have the median period?
I do have some length of custody data. I do not think I have data about longest period. I've got some average.
Why don't you give me what
datas.
you've got, Miss?
Yeah. So, what have we got here? So, in the 12 months to June 2021, the average number of days on remand for a 10-year-old, none, obviously, because there were none. on remand. For an 11-year-old was 3.8 days, for a 12-year-old was 3.1 days, and for a 13-year-old was 7.1 days.
All right. You don't have median times, and you say you don't have maximum times?
I have
there, is that
average. I have average times.
Could you provide the maximum times as well on notice?
I would have to check whether that data was available or
Yes.
not, but if it is available, I can provide it on notice.
Yep. Ms. Hitter, I'm going to show you two documents, and actually there are three documents, and I'll be careful how I describe them on the record. One is a letter from the Legal Aid Board of the 9th of March. Another is a letter that went to the chair of the Legal Aid Board on the 21st of December, sorry, the 9th of March this year. The first one, the 21st of December last year. And then there's also some holding correspondence back from the chair of the Legal Aid Board on the 3rd of February 2022. I'll show you the three documents. You're familiar with those documents?
I am.
The end outcome of that was a request for review by the board in relation to those matters was declined by the chair of the board. Do we agree with that?
The chair, the chair made a determination that it wasn't something that needed to be put before the board. Yep.
And I think if you look at the final paragraph of the 21 December correspondence, the request is that in the absence of the board looking at it, the matter be referred to the attorney or to the secretary of DPC. It's the final paragraph of the 21 December, the longer 21 December correspondence. Do you see that?
I do.
Has that happened?
Not to my knowledge.
Could the documents please be provided to the secretary?
Sure.
Mr. Ball, I don't wish to, I don't think it's appropriate to go into detail about the substance of these matters. But it's fair to say matters of substantial concern were raised in the correspondence to the chair of the board. And then you'll see from the most recent correspondence, which is the more darkly coloured copy, the response from the board. Do you see, to the chair of the board?
Yes, I do.
Showing the matter did not go to the chair of the board, and indeed, in making that determination, the chair relied on a report, I think, from you, Ms. Hitter, is that right?
I provided advice to the chair, that's correct.
Mr. Tidball, one of the reasons this matter was raised with my office very recently was because there was a very real wish on the part of the person making these concerns, raising these concerns, to have somebody outside of legal aid to review these matters. And there is enormous, there's very real concern expressed back to me that, again, the decision was made entirely on information that has come from the agency where the concerns are found, where the concerns lie. Would you be in a position to seek further advice in relation to this and then on notice indicate what, if anything, and I'm not asking for a course of action now, what, if anything, may be done in relation to this?
clearly, I am Secretary of the Department. I cannot express it this way because I'm being very mindful of where my role starts and finishes. As the Secretary of the Department with a cluster responsibility, I would certainly be happy to confer with the attorney, who I believe is the appropriate person, and to seek to address that question of independence, which I believe is at the heart of what you're asking.
Yes, Mr. Boyd. And look, I'm not expressing a view one way or another about Ms. Hidder's involvement, the report, the conduct of the board.
Of course.
But the request here is to have somebody outside of legal aid at least cast their eyes over these matters. But whether or not that's achievable, whether or not there's a process that can be done, you'll consult with the attorney and respond on notice.
I hear you, and I will take that on notice, and am happy to, in appropriate terms, report back in due course.
Yeah, indeed. And in no way am I dictating the nature of the response. It'll be under advice, the response. They're my questions.
I've got some more questions. Thank you. Mr. Tidball, on the last occasion, on the 1st of November, when the attorney and I were discussing the issue of the attempted police suppression order against the Friendly Geordies program, we were discussing the Open Justice project being conducted by the Law Reform Commission. There was an issues discussion paper put out. There were a number of very good submissions on the Law Reform Commission website. The attorney, I think, was hopeful at that stage that there would be a final report by Christmas. Again, to be fair to the attorney, he didn't specify which Christmas. But I note on the website this morning and in weeks previous, there's still no final LRC report on Open Justice. Do you have any indication from the LRC when that might be forthcoming?
I, with your permission, would like to refer this to Mr. McKnight, if I can.
Yep.
So you'll appreciate the Law Reform Commission as an independent body. It undertakes its deliberations free from whip cracking from the department.
Yes.
And it's reasonably important. At this stage, we don't have a final date expected for that report. But I do know that they are working on finalising it as quickly as they can.
Is it possible for you to take on notice that query? Obviously, they're under no obligation to tell us. Well, we can't. You can't tell them what it is. But if you could ask, that would be
to get an indication.
That'd be very, interesting and useful. The next question I've got is a bit odd. I wasn't expecting this, but in another budget estimates hearing, PC4, in terms of lands, on the 9th of March, I think this was in relation to a question raised by my friend Mr. Shoebridge. The issue came up about the Attorney General extending the interim arrangements in relation to the Catholic Metropolitan Cemeteries Trust. Now, none of the departmental officials in PC4 were able to assist Mr. Shoebridge because their view was that this was a matter for the Attorney General. And Mr. Shoebridge asked if the Attorney General had sought advice, and if so, what advice was given to the Attorney before extending the interim arrangements in relation to the Catholic Metropolitan Cemeteries Trust. So I'm just wondering, and again, I don't expect, unless the Crown Solicitor was involved in that process, are you able to cast any light on this matter, either here today or on notice?
Possibly with assistance, yes.
Yeah, this would be really good.
Yes, and thank you, Mr. Sewell.
That's okay, Mr. Shoebridge.
Pointing out my inadequacies.
No. It's a very interesting issue.
Good.
I think it was probably a matter that you perhaps should have put to the attorney this morning.
There's a number of matters I should have put to the attorney this morning, but time was against us. I had to prioritise.
It's not a departmental matter as such, but
well, just on that, Mr. McKnight, is that? I mean, the attorney has a number of legal powers, but presumably acts on advice from someone.
Yes, and in his capacity as the protector of charities,
Yes.
and the like, he seeks advice both from the department and from Crown solicitors.
Yeah, my imperfect recollection is when the attorney exercises these legal powers, although the department might put a, don't take this the wrong way, sort of a policy lens over the top of it, the primary advice tended to come from Crown Solicitor's office. Is that correct, Ms. Smith? Do you have any recollection about this?
I do know that we provide advice to the attorney via the department on charitable trust matters.
But what about this particular matter, extending the interim arrangements with the Catholic, make sure I get the right title here, Catholic Metropolitan Cemeteries Trust?
I do know of a matter involving cemeteries that's before the court. I'm not sure if that's the matter you're talking about.
No, it's not. These are the interim arrangements made under superseded legislation. I think temporary arrangements were extended to 2024, possibly?
Correct. This was a regulation-making power by the attorney to maintain now defunct regulations since Crown land changes, to continue that arrangement in place so as the Catholic Metropolitan Cemeteries Trust continues to operate as it had before those legislative changes.
And I guess what we're interested in is what motivated that. I mean, it seems that you would have thought the policy advice might have come from Crown Lands. They said it didn't. They said it was the attorney, which is fine, but the attorney presumably acted with some input from you guys.
So that information I don't know.
That's
perhaps it would be best if we took this question on notice and got
Yep.
the answer in writing from the AG.
Yep, you certainly can. And to assist, I have the relevant extract from the transcript of the PC4 proceeding, which I'm happy to hand up via the Secretariat, just to assist.
And when it's been taken on notice, that's on behalf of the department broadly, which includes the Crown Solicitor's Office.
On this occasion, I think that the answer will come back to you through the AG.
Yep, no, that's fine. Okay. Good. If you've got some questions, I've got quite a few, but
it flows from that.
Please.
Ms. Smith, you indicated there was some confusion in the Crown Lands hearing about whether or not proceedings were on foot in relation to CMCT trust property and the use of Catholic Metropolitan Cemetery Trust funds. At one point it was indicated there were proceedings on foot, at another time it was indicated there may have been some legal advice exchanged. You indicated there were proceedings on foot. Can you tell me what those proceedings are and who the parties are?
There are proceedings between the Rookwood General Cemeteries Reserve Land Manager and the Attorney General.
Rookwood General's Cemetery Reserve Manager. And what is the nature of those proceedings?
Those proceedings concern the questions. The proceedings are brought by the Rookwood General Cemeteries Reserve Land Manager. So the nature of those proceedings would be, I think, best asked by them. The Attorney General's interest in the proceedings is as the protector of charities.
Well, the Attorney General must know the nature of the proceedings brought against him, and I assume the department would know the nature of the proceedings brought against the attorney.
Oh, no, I don't. No, the Attorney General has sought to be joined to the proceedings as the protector of charities.
All right. So was it declaratory? What's the nature of the proceedings?
They are judicial advice proceedings concerning the charitable or concerning the management of the cemeteries.
Is it concerning the use of trust funds? Allocation of trust funds?
No, I don't believe so. I think it's the nature of the trust.
All right. Does it relate to assets held by the CMCT, the Catholic Metropolitan Cemeteries Trust?
I don't think so, no.
Has the department in any way been is the department in any way aware of any issues in relation to the use of the Catholic Metropolitan Cemetery Trust funds? Mr. McKnight?
I need to take that on notice.
All right. Ms. Smith, where are the Rookwood General Cemetery proceedings brought? In the Supreme Court? In the Equity Division? Can you provide on notice the details of the proceedings,
Yes.
including the matter number? And if you're able to, can you provide a copy of the filed pleadings on notice? I'm more than happy for you to take that on notice.
I'll take that on notice.
Right.
And if you aren't able to do that, at least tell us what the matter number is.
I asked for that separately.
Oh, you did, okay. I wasn't listening. You done? Just turning back to victim supports, the longest time to determine an application for immediate needs in the financial year 2020-21, I think, was 2,436 days. Are you able to, on notice, advise as to what the delay was, and what the immediate needs that individual was seeking?
Yes, we could take that on notice and do our best to, I'll do my best to answer that. But I would add separate to that, if it's okay.
Of course, no, please.
There has been a history of delays in responding to applications in victim services, and reforms implemented by the Commissioner in the last couple of years have really improved assessment times and service provision. But one of the issues there is that if a legacy or an old matter is resolved, the day count takes into account all of those days, and the clock stops on the day it was resolved. So it's common for some applications to have very long timeframes for that reason.
Yes, but 2,000 days is a very long time.
Of course it is, yeah. So we'll do our best to find an explanation, but for immediate needs, the current average time is 11 days.
Okay, well, that's good. In 2021, apparently 0 complaints were resolved through the Commissioner. Is that because it's difficult to access the Commissioner's sort of dispute resolution function, or is there another explanation?
I know that there are senior staff within the victim services team who respond to, who review decisions in response to requests for review, or who deal with complaints. Whether the Commissioner has herself not responded to a complaint doesn't mean that the complaint wasn't managed or dealt with. Is there a particular complaint in relation to that?
No, it was just more a sort of systemic
process.
Yeah, I was just more interested. Yeah, I think so. I think that'd be good. In relation to victim support requests for counselling, financial assistance, immediate needs, financial support, economic loss and recognition payments, those 4 categories, can you tell us how many applications were received, awarded, pending or dismissed between 1 July 2021 and roughly the present?
I can give you numbers up to December.
Oh, that'd be great.
Yes, I can, from last July up to December. So for counselling, we've had 11,264 applications with 98.6% approval rate. For immediate needs, we have had 3,716 applicants. For economic loss, 4,800 applications. For recognition payments, there have been 7,570 applications. Now, for each of those categories, compared against the same period in the previous year, July to December in the previous year, for counselling, that's an increase of 31.8%. For the total financial assistance, it's an increase of 29.1%. And for recognition payment, it's an increase of 30.9% in applications.
Okay.
We have technically run out of time, but I think with everybody's indulgence, it may actually be better if you've only got another few minutes, Adam, another 10 minutes or so,
No pressure.
we proceed on. I have like 2 minutes of questions.
Okay, well, we'll go back to you. I can
Aim to finish by, at the latest,
3:40.
3:45 and have it done, or we can take a break and come back. What would the witnesses prefer? If anybody needs a break, it is...
Don't mind.
If anybody needs a break...
There's some tea and coffee.
No,
Happy to keep going.
we're happy.
People
I'm
can
serious.
take their own
If any witness wants a break, we can have a short break now. But if you'd rather just have it end, we can press it. I think I see nodding. Okay.
Furious agreement.
Did you want me to ask questions briefly?
Yeah, you ask your questions and I'll try and finish off mine.
The Court Security Act, does that fall within the Attorney General's bailiwick? Yes?
Yes.
And on the 11th of March this year, so 4 days ago, I think that's right, a woman was arrested for allegedly posting an image from within the Downing Centre, which included the court list, and on that court list was a matter of some notoriety, Mr. Houston, of a certain church. Was a complaint made to the department? Was a complaint made to the courts that led to this woman's arrest, her searching, and her detention for some 5 hours?
I'm not been briefed on this, not aware of this at all.
And the same here, Mr. Shoebridge, but for abundance of caution, we are happy to make inquiry and advise the committee.
I am briefed on serious security matters regularly, but this one's not on my radar at all.
So the woman in question was literally arrested at her home, had police attend at her home within 36 hours of allegedly posting the image, which is allegedly a breach of Section 9 of that Act. Is there a protocol between the courts and the police which would, for the passage of such information, Mr. O'Reilly?
Well, only in that when any of us are aware of a crime, we have a duty to report the crime. But I need to know a lot more about this incident to really know if it's relevant, because if the police attended at the person's home and arrested the person at their home, I don't know who reported that person to the police. It may not have been the court. It could have been anybody, from what the information I have so far.
Indeed, it's the question I'm asking you is whether or not a complaint went through to the court, which was then communicated to the police. You don't know?
No. Again, I haven't been briefed on this matter at all.
All right. I can't tell you the frustration of the individual involved who had been seeking for years to have the substantive matter dealt with, which she was attending court to see, but found, indeed, the police acted with such alacrity for an alleged breach of Section 9 of the Court Act. But you'll take it on notice about whether or not there was any complaint received by the courts or the department, and if so, that was whether or not that was the avenue which the matter came to the police attention.
Yes. Happy to.
Sorry, just before we move on, do you know of any other matters where individuals have been prosecuted for the alleged breach of Section 9 for the taking of photographs or images in the Downing Centre in the last, say, 3 years?
I don't, but again, at the risk of repeating myself, I'm new to this area, so I'm not aware of any cases, but I'd have to check whether there are any cases.
Could you take that on notice? Sure. Mr. Scott.
Oh, thank you. I have a lot of questions which I'll largely put on notice, but I think just to round us out for the next little while, can you tell us when the Victims Advisory Board met between 1 July 2021 and present time?
I can, if you'd just give me one moment. I don't have the days. It met in July and again in October.
Okay, so twice.
Twice.
Okay.
Twice since July.
Okay. Is there any sort of record published of what's discussed at these meetings, or what are the issues to be discussed at the meetings?
These were before my time, so I can't report on them myself, so I'll have to take that on notice and come back to you.
Okay.
They're generally used for consultation on policy and also for the advisory board to provide advice to the department and the Attorney General on issues in the community.
Okay. I think, Mr Tibble, I'll come back to you for this one, and you can farm it out if it's not with you. How much funding was allocated in New South Wales from the $129 million worth of Commonwealth funding allocated to women's legal centres to respond to women experiencing family violence? Mr McKnight.
I think we'll have to take that
take it on
on notice, Mr Searle. I don't have the figure with me at the
That's
moment.
okay. And when you are taking that on notice, could you give us the breakdown as to how much was allocated to legal aid, New South Wales?
Yes.
The Aboriginal Legal Service and Community Legal Centres, New South Wales?
Yes.
Both in dollar terms?
Yep.
And as a percentage of the overall amount of money?
Yes.
In the interests of time economy, I think I might reduce the rest of what I've got to supplementary questions, and depending on the adequacy of answers, follow them up at the next occasion.
I think a position endorsed by the rest of the committee too,
Yes.
Mr Searle.
I think this is where we're heading.
It's now the government's opportunity to ask the usual rigorous round of questions. Mr Paulus, Mr Amato.
Well, for the benefit of the committee, Mr Deputy Chair, the government won't be raising any questions.
All right. Any further questions will be on supplementaries and notice. Is that right, Mr Paulus?
Well, we'll consider it carefully.
Okay. Could I thank everybody for their... Oh, Ms Boyd. Yes.
Yeah, I just wanted to finish an answer to a question that Mr Searle asked earlier about local government election offences.
Yes, please.
I've received a very helpful missive from our friends at the Electoral Commission, and they have confirmed that yes, the Electoral Commission does have the function of enforcing those offences, and the bit in the candidate handbook that you referred to is actually in the section about the nomination process, and candidates are advised that the returning officer and the Electoral Commission cannot determine for candidates whether they are or are not a property developer. That has to be a factual assessment of the candidate, but that doesn't mean that the Electoral Commission doesn't investigate offences about factual inaccuracies in those
False
candidate
declarations.
information sheets. Yep.
Very helpful, Ms Boyd. Thank you very much.
Are there any further
Revelations?
answers before we going once? No. Again, well,
Before we go, I just want to table...
well, we can do all that.
Do that. Do I have to table it here?
All right, we'll
Or can I
consider
do
it tabled.
I can do it. Well, I will formally table the thumb drive that had the videos dealt with earlier, and we'll deal with this in a
All right.
deliberative shortly.
Sure.
Right. Again, can I thank all the witnesses for their attendance? There's 21 days in which to provide answers to questions on notice. Secretariat, as always, will be of assistance in giving you the clarity about what those questions are. Mr Amato has just been kicked off the committee, and that concludes the hearing for today.